Can it be on Monday, Lordship?
Why Monday?
Why not urgency there because the matter relating to Lordship, payment of salary, Lordship. Obliged.
Me please, your lordship. Lordship, like to mention two listing of two matters, your lordship. Lordship, notices have been issued, lordship, in 2 months back, lordship, but matters have not been listed yet. Lordship, I'm praying for any date, lordship. Two matters, lordship. One is regarding to pay non-considerable pay scale,
11, 16,
11,
16.
16th of August. Lordship, any other date, maybe on
19.
19, your lordship, much of it.
May I please, Lord, non-payment of salary, my lord, may I pray for listing the next any convenience day,
Yeah. Okay, 14th.
14. Obliged.
My lord, I and similar prayer, my lord. Pension.
Okay. 16.
16.
May I please repeat?
Wait, please, my lord, I have filed a interlocutory application, my lord, in WBC number 1488, and this retribution is fixed on, my lord, 8. My lord, pray, my lord, may I pray, my lord, to read this IA on 8, my lord.
On 8.
My lord. Retribution is fixed on 8, my lord. Obliged.
Lordship, I beg to mention for listing, Lordship.
Hmm.
Pending cases, Lordship. Pending in admission case.
Okay. 19.
Lordship.
Please, your lordship, lordship, I beg to mention item number 24 for hearing, your lordship, daily cost list, your lordship.
24.
24, with the consent of the other side, your lordship, matter will be adjourned, your lordship.
Yeah, petitioner.
Yes, your lordship.
2017 matter.
Yes, your lordship. Mr. Ganguly is not keeping well, your lordship.
Okay, on request made on behalf of A. Ganguly, let me counsel for the petitioner. When?
20th August, my lord. I am for the college, my lord. 20th August, my lord. So hearing, my lord.
Yes, sir. Okay.
May I
Awesome.
please, your lordship? I beg to mention item number 8. Possible for a day, lordship. I should read, but
Huh?
My lord,
I shouted.
I should read, lordship.
I am for the respondent college, my lord.
Hmm.
But there is some urgency in this matter, my lord. So it's praying for tomorrow, my lord.
Tomorrow.
Yes, my lord.
Tomorrow.
Thursday, my lord, on 8, my lord.
On request made on behalf of I shouted, Leonard, senior counsel for the petition. This is the matter on 8.
No, I think he is not senior counsel, my lord. Oh, he's.
My senior, lordship.
Oh, yes, sir. Don't say so. Leonard counsel for the petition. Huh?
Lordship, I have another prayer, lordship, for listing, lordship, pending matter,
Pending matter.
lordship.
Okay. 21st.
Lordship, for admission, Lordship, on 19, Lordship.
21st.
May I please, Lordship, I beg to mention item number 26, Lordship.
Yeah.
Lordship, kindly adjourn this matter. My senior is not feeling well.
Who's your senior?
SK Dash.
That goes with item 27.
26, Lordship.
No, 26 is with analogous with 27.
Because
Where's Patak?
Lordship, 26. Lordship. Wahiduজ্জামান.
26 is with 27. Isn't it? Okay, on request made on behalf of SK Tha, Learned Council for the petitioner in WBC number 4151 of 2017. When do you want?
Next week.
List the matter after 1 week.
May I please, your lordship? Lordship, I beg to mention for listing of a contempt case for orders next week, lordship. Any date next week?
16.
Oh, bless lordship.
One of daily admission.
Wait, please, Lordship.
Oh.
That matter, particularly, basically, my lord, petitioner was, my lord, here, my lord, initially appointed as a contextual teacher, my lord.
Hmm.
At the Sajnikanta Higher Secondary School in the Borbata district, my lord. He went to on leave on childcare, my lord, childcare leave with effect number 1 on 16 to 17 12 2017, my lord.
From?
From, my lord, 1 on 2016, my lord, for 2 years, my lord.
You?
For 2 years, my lord. 1 on 2016 to my lord, 17 12 2017, my lord. 2 1 2016 to 17 12 2017.
2-1.
2-1, my lord. And after completion of the leave, my lord, that leave was, my lord, granted by the school management committee, my lord. Subsequently, after over of the leave, my lord, while the petitioner had approached the concerned principal, my lord, for resuming her duties, my lord, she was not allowed to resume her duties.
Why?
My lord, saying that no, my lord, there is no cause of shown by the principal. She was simply rejected. Her subsequently, my lord, ultimately she had to send that joining letter, my lord, through registered post, my lord. I have already annexed, my lord, to my writ petition. Anyway, my lord, now, my lord, after filing of the writ petition, my lord, the director of secondary education, my lord, had filed the affidavit, my lord, saying that contractual employee, my lord, like the petitioner, are not entitled to child care leave, my lord. And moreover, they have also, my lord, given up their responsibility, saying that leave was sanctioned by the president of the school management and development committee, my lord. Now, my lord, kindly see there, if stand in the affidavit, my lord, paragraph 4, my lord, page 40, my lord, turning page 40, my lord.
Huh?
Running page number 40, my lord, paragraph 4.
In the affidavit in opposition,
Yes, my lord, opposition filed by the director, my lord.
page 43.
Page 40, my lord.
43.
Then, my lord, it is, anyway, it is there, my lord, 40. Anyway, I am reading the paragraph 4, my lord. Paragraph 4, my lord. That after going through the contention and averment made in the respective paragraph of the petition, it is transferred that the petitioner initiated the instant petition seeking direction to allow the petitioner to resume her duty as assistant teacher in the English at Rajanikanta Higher Secondary School, Gorpata, and to that effect, she had submitted an application on 16/12/2017 before the president of the School Management and Development Committee of the school. But till date, no action has been taken. In this respect, your dependent begs to submit that the petitioner was engaged as an assistant teacher English on contractual basis in Rajanikanta Higher Secondary School, Gorpata on 5/8/2010. Filed memo number so which was approved by the Inspector of School BTC Borpata. However, from the verification of the report dated 5/11/2018 received from the principal of Rajanikanta Higher Secondary School, Borpata, it was found that after completion of a medical leave on 11/3/2016, 14 to 7/6/2014 for 90 days without pay, the petitioner was again granted leave on medical ground as well as maternity leave. My lord, what happened, my lord, during this pregnancy, my lord, she had some medical complication, my lord. Anyway, leave with effect from 8/6/2014 to 1/1/2016, and child care leave with effect from 2/1/2016 to 17/12/2017 by the president of the School Management and Development Committee of the said school, which was extended at an interval of 90 days from time to time by various orders. However, no copies of such orders were forwarded to the Inspector of School PTC Borpata. Moreover, the principal of the said school filed letter dated 15/11/2018 stated that Mr. Mohanlal Das, President of the School Management Committee and Development Committee of the said school, had alone granted the above mentioned child care leave to the petitioner without any resolution of School Management and Development Committee. Now come to paragraph 5, my lord. That the defendant further begs to state that in the agreement, the model form of contractual engagement of teacher as per government notification and so and so, in point number 7, it is stated that party will be entitled to a leave on pro rata basis of 2.5 days per month. Period. When leave is to be taken should be agreed with the president of the SMC. My lord. Leave not available during the month shall lapse after the month is over. Further, there is no such provision for child care and maternity leave during 2014 to 17 for the contractual employee working under the secondary education department. It is their statement. Now to that affidavit of opposition, my lord, I have filed my counter affidavit, my lord. Here, my lord, lordship will find, my lord. Kindly come to page, my lord, 62, my lord. Here in this case, my lord, I just wanted to point out, my lord, one thing, my lord. The petitioner child, my lord, the boy is, my lord, special child, my lord. Anyway, my lord, come to page 59, my lord.
Our pages are not telling which annexure.
I'm now have taken the PDPD decline method. Page 59 method.
What is that?
That is the joining letter method after completion of the leave method. Sorry, method. The page 62 method. Annexure B, page 62. Page 62. This is the joining letter method. It is dated 16/12/2017 method. To the principal, Sajaniganta Higher Secondary School.
1 minute, that is not the correct one. Yeah.
Here, my lord, pray for permission to join with the post of contextual teacher in English, from where I proceeded to child care leave. My lord. That letter, my lord, that was submitted on 16/12/2017, my lord. Here, my lord, kindly see the NB, my lord, NB part, my lord. Here, my lord, there, sir, as I have not got any response from your end for my joining and not got receipt of this letter, I am sending this letter through post office for your disposal, and again I pray to the competent authority, that is School Management and Development Committee of Sajaniganta Higher Secondary School, Gorbata, wrote to consider my prayer so that I may be allowed to join this, my lord, college, my lord, school. Here, my lord, this was, my lord, sent through registered post, my lord. Subsequently, my lord, while the petition was pending, my lord, your lordship has directed, my lord, there is an order, my lord, page 64, my lord. Passed in this instant petition, my lord. Order dated 2/8/2022, my lord. Yeah, my lord. The lordship, my lord, this could have by last but two paragraph, second paragraph, my lord. By way of interim, the petitioner is directed to approach the principal of the Sajaniganta Higher Secondary School, Gorbata Road, on or before 9/8/2022. Therefore, thereafter, the concerned authority shall pass appropriate order permitting the petitioner to join her contextual post, my lord. My lord, after receiving this certificate of this order, my lord, the petitioner submitted the same, my lord. Next page, my lord. It was submitted on 5/8/2022, my lord. Here, my lord, to the principal, Sajaniganta Higher Secondary School, reference Guwahati High Court, case number so and so, by way of interim order dated 2/8/2022. With due respect, I beg to state to your honor that as per direction of the interim order dated so and so by the Honorable Guwahati High Court, I am approaching to you and today, that is 5/8/2022, for joining to the post of contextual teacher in English, from where I proceeded to CCL. For my son, Antariksh Das, who has 90% temporary disability certificate. Under the circumstances, your honor, be pleased to do the needful so that I may be allowed to join to the post of contextual teacher in English. That's all right. This letter, my lord, that was duly received, my lord. Next page, my lord, page 67, my lord. That was duly received by the principal, my lord. But till date, my lord, the principal has not allowed the petitioner to resume her duties, my lord. Anyway, my lord, so far, my lord, they are stand, my lord, on the affidavit in opposition, my lord, regarding the granting of child care leave, my lord. My lord, this issue has already been decided by this honorable court, my lord. In my lord, Dolly Gogoi case, my lord, I have already submitted that copy of the judgment, my lord. Here, my lord, says that the contextual employees, my lord, are also, women employees are also entitled for child care leave, my lord. There is no application of pro rata basis, my lord. Here, my lord, your lordship may kindly come to page paragraph 13, my lord. May read paragraph 12, my lord. From 12, my lord, it will be clear, my lord. May I read, my lord?
Yes.
My lord, paragraph 12, my lord. Government of Assam in the Finance Department had issued notification dated 13/7/2015 providing for child care leave. A perusal of the said notification, which has been placed on record as Annexure 12 of the writ petition, would go to show that the decision was taken by the government of Assam for grant of child care leave for to women employee of the state government. Following such decision, subsidiary rules 121(2) has been inserted in the fundamental and subsidiary rules providing for the childcare leave. It says that women employee having minor children, that is up to 18 years of age, may be granted childcare leave by the authority competent to grant leave for a maximum period of 2 years, that is 730 days, during their entire service for taking care of up to 2 minor children, whether for rearing or to look after any of their needs like examination, sickness, etc. Therefore, the grant of childcare leave to a woman employee would relate to looking after the need of her minor child. SR 121-2 as extracted in the notification dated 13/7/2015 also provides that such leave may be availed in more than one spell. Such leave may be combined with leave of any other kind if given admissible, and can also be extended for the third year but without the leave salary. Nature of childcare leave shall be like earned leave and shall not be debited against the leave account. However, childcare leave cannot be demanded as a matter of right, and an employee cannot proceed on such leave without prior sanction of leave by the competent authority. SR 121-2 as notified notification dated 31/7/2015 enables women employee to take care of their children till such time for children attain majority. When the provision of SR 121-2(3) says the childcare leave may be availed in more than one spell, it would be necessarily imply that such leave can be availed either in one spell or in more than one spell. How the leave is to be availed is left to the discretion of the woman employee, who certainly would be in a better position to assess as to how best to utilize the childcare leave for the best interest of the child. I come to paragraph 13. Entitlement of a woman state government employee to childcare leave was gone into by the this court in WBC number 2146 of 2016. Dr. Santona Thakuria versus State of Assam, which was decided on 24/6/2016. Referring to the provision contained in the government notification dated 31/7/2015, it was held that the provision providing for childcare leave is a beneficiary provision and therefore must receive liberal construction at the hands of the authorities. A reference was made to Article 42 and 21 of the Constitution of India. This court held that the concept of childcare leave is something which is wholly in consonance with Article 42 of the Constitution of India, as well as the expanded meaning of right to life is granted by Article 21 of the Constitution of India. It was held as follows. This is a beneficial provision and therefore, provision and perforce must receive liberal construction
Okay,
at the
I've
hands.
seen it.
Now, my lord, here, my lord, that leave, my lord, that they are demanding on the pro rata basis, that was, my lord, interfered with this court, my lord. They are saying that no, their childcare leave should be granted as childcare leave, not on pro rata basis, whether the woman employee is contractual or permanent employee, that does not matter. That has been interfered by this court, my lord. And in this case, my lord, in Dolly Gogi case, my lord, what happened when, my lord, in the Dolly Gogi case, Dolly Gogi did not, my lord, inform the department on childcare leave. In the present case, my lord, the petitioner was granted childcare leave. My lord.
Where's that notification? 31 July.
My lord, notification is annexed with my read petition, my lord. My lord, page 37 of the read petition, my lord. Last paragraph.
Oh.
Now, my lord, since the petitioner has already been sanctioned the childcare leave, my lord. Now, my lord, there is no question, my lord, debarring her from reasoning her duties, my lord.
Where's the application for childcare leave?
My lord, sanctioning letter, my lord, initially it was sanctioned, my lord. Page 21 for onwards, my lord.
Page
21, my lord. there are several orders, my lord. And subsequently, my lord, the petitioner had intimated for extension of childcare leave, my lord, that was accepted, my lord.
Next, 1, 3. Twelve. So you were granted childcare leave up to
Of
12/12/2016.
My lord.
Hmm?
My lord.
Then after that,
After that, my lord, while petitioner had approved the principal, my lord.
no, you said you took care leave up to 17/12/2017.
Yes, my lord. My my lord, page 33, up to page 33, my lord. On 6/12/2017, my lord. These are the letter, my lord, for extension of the childcare leave, my lord.
Were you granted? Were you
Yes, my lord,
granted?
that was admitted, my lord.
No, so far the granting of your childcare leave is concerned,
My lord.
it's only up to 12/12/2016.
My lord, initially, my lord, it was 12/12/16, my lord.
After this, you
Yes,
make your applications.
Thereafter, my lord, petitioner submitted application, my lord, that was sanctioned, my lord.
Where's the
The
sanction? of-
sanction letter is not here, my lord. In that affidavit, my lord, that is there, my lord. In their affidavit, my lord, it was there, my lord.
Yes.
Yes, my lord, it is there, my lord.
Sharma?
My lord, childcare leave, my lord, it is benefit.
But it is the principal who has to explain, isn't it? Why she's not, why the
Yes,
petitioner
yes,
is
yes.
not being allowed? Who appears for the principal?
No words.
Is the principal's copy,
My lord, principal as well as inspector of school also, my lord. Because
are they
this-
represented?
I am representing inspector of school here, man.
Hmm.
That's on the number 112. And she was initially appointed by SMDC. And thereafter, my lord, a school of inspector.
Notice has been served on.
yes, yes, my lord,
Principal.
receipts are taken, yes, my lord. My lord, even my lord, the principal, my lord, this order, my lord, that interim order, my lord, that was duly received by the principal, my lord.
Hmm.
Even my lord, on that, my lord, the principal did not act, my lord. Even after this honor course direction, my lord.
There was a contempt case.
Yes, my lord, I had filed in contempt case, my lord. I was due to late, my lord, I had to, my lord, withdraw, my lord.
What?
It was filed in the 2023, my lord, 24, my lord. And the lordship was not inclined to issue notice, my lord. That's why that was closed, my lord.
Yes.
My lord, here initially she was appointed by the SMDC and thereafter it was approved by the School of Inspector, my lord. And my lord, so far her leave is concerned, my lord, on page, in our affidavit, paragraph 4, last paragraph.
Hmm.
However, from the verification of report dated 5/11/2018, received from principal of Sajani Kanta Higher Secondary School, Borpeta, it was found that after completion of her medical leave 11/3/2014 to 7/6/2014 for 90 days without pay, the petitioner was again granted leave on medical ground as well as maternity leave with effect from 8/6/2014 to 1/1/2016 and childcare leave with effect from 2/1/2016 and to 17/12/2017 by the by the President of School Management and Development Committee of the sale school, which was extended at the interval of the 90 days from the time to time by various orders. Well, here she submitted an application after 730 days and which was mandatory to submit application in 730 days in the notification 31st July 2015, my lord. It is page 37 annexure P of the writ petition.
Yes.
In here, my lord, SR 121-2, here it is stated, women employees having minor children up to 18 years of age may be granted childcare leave CCL by an authority competent to grant leave for a maximum period of 2 years, that is 730 days, during their entire service for taking care of up to 2 minor children, whether for rearing or to look after any of their needs like examination, sickness, etc., subject to the following conditions. And so, my lord, here in the Dolly Gogoi case also it is mentioned. Here in paragraph 12, SR 121-2 as extracted in the notification dated 31/7/2015 also provides that such leave may be availed in more than one spell. Such leave may be combined with leave. My lord, combined. It is a
Where are
combined
you
with
reading
leave
from? You are reading
of any
from?
other kind of leave due and admissible, and it can also be extended for the third year. Spell and due and admissible, and citation is Dolly Gogoi.
You're reading from which paragraph?
Paragraph 4, my lord. Paragraph 12.
Hmm.
Combined with leave of any other kind if due and admissible, and can also be extended for the third year, but without any leave salary. And moreover, my lord, and here, my lord, as per our government notification and paragraph 5 of our affidavit in opposition, it is mentioned that the party will be entitled to leave on a pro rata basis of 2.5 days per month, and period of leave is to be taken should be agreed with the president of SMC. Only limited to 2.5 days per month.
No. You're reading from where?
I am reading from this, my lord, our affidavit in opposition and chapter 5.
Hmm?
0.5, my lord, in our affidavit in opposition.
Paragraph 5.
Paragraph 5.
Yes.
And beyond that the level, my lord, he is not competent authority. He is only competent authority only 2.5 days per month.
Who is to grant the childcare leave?
Basically, inspector of school.
SMDC.
And she was appointed by the SMDC. So SMDC.
So the president granted the leave.
Yes, but as per notification that the party will be entitled to live on pro rata basis 2.5 days per month, and the period when leave is to be taken should be agreed with the president of SMC.
What notification?
It is a notification by PMA S 32/2010/20 dated 10/6/2000.
Where is this?
In our affidavit, it is paragraph 5.
No, where is this notification? You have annexed.
I have not annexed it.
Basically, my lord, it is a model form of agreement, my lord. Contextual agreement. That is the model form, my lord. There in that agreement, my lord, it was there, my lord, that 2.5 days per month leave will be entitled by the contextual employee, my lord. Now that part, my lord, that has clearly, my lord, interfered by this honorable court in Doligogi case. They are saying no, that leave is severed, but childcare leave, so childcare leave, that is contextual women employees are also entitled to childcare leave. They are saying that childcare leave is cannot be granted to the contextual employee. My lord. Their basic concept was that. Now, my lord, that
So
is
from 2017 till today, you have not joined the,
no, my lord, not allowed, my lord. Not allowed. That is why my, this case was filed in the 2018, my lord. This petition, my lord, was filed in 2018, my lord. Till 2017, my lord, she was fighting, my lord. But no response, my lord.
and your, your, what you call that, contractual engagement of teachers.
My lord.
It is for how many, which period?
My
Or
lord,
it is-
initially, my lord, it was extended, but subsequently, my lord, there is no extension, they are allowed to continue, my lord. Initially, my lord, they were engaged on contextual basis, my lord, for some period, my lord, 1 year, 1 year.
Mm.
Thereafter, my lord, no engagement or the renewal was there and they are allowed to continue, my lord.
By which order?
Well, no specific order is there, man. But they are allowed to continue, man. They can answer it, man. The contractual employee, man, they are still working, man.
But my lord, in Doligogoi case, she was appointed on due process of selection. So here, my lord,
this
she was appointed by SMDC. And which was approved by IS.
So that you have approved.
At the time,
So the government has approved.
IS approved.
Exactly. But the petitioner's appointment has been approved by you.
And thereafter, it was
And thereafter
extended by,
petitioner is
by the
continuing.
whim of the SMDC.
Is continuing, and then she applied for the CCL. And that was also granted by the president.
Well, in
So
Doligo,
what is the hindrance for the principal not to allow the petitioner to join back to service?
Regarding the principal.
my lord, one point I want to just point out before you lost my lord. After passing the interim order, my lord, 2/8/2022, my lord, while petitioner had approached the principal, my lord, the principal, my lord, did not allow her to join, my lord. The principal informed the petitioner, no, until and unless the case is final, we cannot allow you to join. There is a verbal, my lord. And we had to wait, my lord, long 6 years, my lord.
Yes, Shama, what is your instruction on that?
My lord, it is.
My lord, we have filed our affidavit as per information received from the principal. And therefore it is forwarded by the inspector of school.
My lord, it is squarely covered by Doligo case, my lord. Doligo.
This is what you have stated in your affidavit only.
Yes, my lord. In next paragraph, in next page, the principal has written
what you, how can you help, how are you trying to assist?
no problem.
So in other words, the contractual period of the petitioner still continues.
Till my lord, it was continued 11/3/2014. Thereafter, she was on leave, my lord. 11/3/2014
that's fine.
to 7/6/2014, and again
Up
8/6
to 17/12/2017, petitioner was granted leave,
yes,
correct?
yes.
So after that, is she still continuing as a contractual teacher?
Hmm.
Or the service of the petitioner has been terminated?
In this regard, I have not been getting instruction from the principal. But here, my lord, she is on leave till 17/12/2017, which is exceed then 7.
Any termination
Yes.
order?
No,
issued?
no,
No,
nothing.
no,
nothing. That is why my lord, principal himself have accepted, my lord, that interim order, my lord, and my lord, the leave, my lord, the terminated employee cannot be granted leave, my lord. Definitely he was, she was in service, my lord. That is why leave was granted, my lord. And only, my lord, the institution of the present writ petition only arises, my lord, when she was not allowed to resume her duties, my lord. From that, my lord, this cause of action arose. And she had immediately filed the writ petition, my lord. Only with the prayer to allow the petitioner to resume her duties, my lord. In fact, my lord, her lordship's interim duration also, my lord, was not compliant, my lord. There is another aspect, my lord. And so far the Dolly Goga judgment in concern, my lord, that is in paragraph 14, my lord. Actually, paragraph 13, that quoted part, my lord, that is the, my lord, property portion, my lord, mainly, my lord. Your lordship goes through that quoted part, my lord, it clearly states that, my lord, contractual employees are also entitled, my lord, for childcare leave, my lord. And paragraph 14, just simple line, my lord, I am reading, my lord.
Para 14 of?
Dolly Goga judgment, my lord.
Hmm.
My lord. Actually, my lord, it would be better, my lord, if I allowed to read the quoted part, my lord, paragraph 13, my lord, of the quoted part, my lord. Because on that basis of which, my lord, the principle, my lord, this paragraph 14, my lord. Anyway, I am reading paragraph 14, my lord. Having held as above, it must also be noted that petitioner is, in this case, is not a regular government employee. She is a contractual employee in the role of government with respect to the learned judge of this Honorable High Court in Uttarakhand. A somewhat pragmatic approach may have to be taken with respect to the claim of childcare leave by contractual employee. As in the case, the initial contractual employee was for a period of period which was less than for a period which was less than 1 year. Though subsequently such contractual employee has been extended from time to time. If the initial contractual employee was for less than 1 year, certainly more than that period cannot be granted on account of childcare leave. While the benefit of childcare leave may not be denied to contractual employee, being a beneficial provision.
Okay.
Lordship may kindly dispose of this requisition.
I'm disposing of this matter, Sharma. There's no point. You have not come with any proper instruction. Heard Mr. S. Haq, learned counsel for the petitioner, as well as Mr. U. Sharma, learned standing counsel, secondary division for the respondents, 1, 2, and 3. Stop. Para. The petitioner was initially there was a selection process before your appointment.
Yes, my lord. They participated in the selection process.
Then you said the petitioner on the basis of the recommendation of the selection committee for appointment. as assistant teacher in English on contractual basis in the Sajani Kanda Higher Secondary School
Sajani Kanta Higher Secondary School, Borpeta Road.
was appointed was engaged by an order dated 5/8/2010,
Well.
correct?
Well, yes,
Annexure B,
yes,
order dated 5/8/2010. Issued by the principal, Sajani Kanda Higher Secondary School, Barpita. Stop. The petitioner joined to the said post on 5th of August 2010. Stop. Thereafter, with the approval given by the inspector of schools,
So file order number IS plan APTT contextual APT 2000.
Where?
It is annexure 6, my lord.
Hmm?
Annexure 6.
There's no annexure 6 here.
Annexure C, my lord. C. Just 17. Hello.
This is a joining report.
And the contextual basis being approved file order number IS plan APTT contextual IPT.
that is difference was there.
Hmm?
There's the difference of the inspector school Borpeta. Constitutional basis bearing approved height order numbers IS is 17 minute. Lordship got one. There's a reference file. Approved height order date.
Don't say the inspector of schools, Barpeta, District Circle. By letter dated 4/8/2010.
Hmm.
Approved the petitioner's selection for appointment as assistant teacher in English on contractual basis at the Sajini
Sajani
Kanda Higher Secondary School. But
Borpeta Road. My lord.
after that, you say, after the petitioner joined to the said post on 5th August 2010, correct?
My lord.
Para. No, 5th August 2010. The contractual appointment of the petitioner as assistant teacher in English was extended from time to time and is continued till date. Stop. Para. While the petitioner was serving on contractual basis as assistant teacher, comma, the petitioner was granted childcare leave with effect from 2/1/2016 to 17/12/2017 by the
Ye-
president of the School Management and Development Committee of the school for an interval of 90 days
90.
from time to time by different orders. Stop. Para. Learned counsel for the petitioner submits that after the expiry of the childcare leave on 17/12/2017, comma, the petitioner approached the principal of Satani Kanda Higher Secondary School on 16/12/2017, requesting to permit her to join to the post of contractual teacher in English by uh, 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 in English. Stop. However, comma, the principal of the said school refused to permit the petitioner to join back to service. And accordingly, the petitioner has approached his court by way of the present. So, para. The respondent number 2, Director of Secondary Education, has filed counter affidavit. And in para 4,
Therefore,
and in paragraph 4, it is stated that the childcare leave with effect from 2/1/2016 to 17/12/2017 was granted by the President of School Management and Development Committee of the said school, comma. However, no copies of such orders of the said school by various orders, sir, by various orders on an interval of 90 days. Stop. However, no copies of such orders were forwarded to the Inspector of Schools, comma, BDC, Barbeta. Stop. It is also stated that the principal of the said school, by letter dated 15/11/2018, stated that the president of the School Management and Development Committee of the said school had granted the childcare leave to the petitioner without any resolution of the School Management and Development Committee. Stop. Further, comma, at paragraph 5, it is stated that there's no provision for childcare leave for childcare and maternity leave, during 2014 to 2017 for the contractual employees working under the Secondary Education Department. Stop. Para. Learned counsel for the, no, stop. Yeah, learned counsel for the petition. Relying on the notification dated 31st July 2015. Issued by the Secretary to the Government of Assam. Finance, within bracket, establishment dash A, close bracket, department. Which provides for grant of 2 years. Within bracket 730 days, childcare leave. To women employees of the Government of Assam submits that the petitioner, though she may be a contractual employee, is entitled to childcare leave in view of the ratio laid down by this court in the case of Doli Gogoi versus State of Assam, reported in 2017 to JLG 673. He therefore submits that as the petitioner is entitled to childcare leave in terms of the ratio laid down in the case of
Delhi Public.
Doli Gogoi Supra, comma, the petitioner should be permitted to join back to her post.
Hmm.
Stop. Para. This court has considered the submissions made by the learned counsel for the parties. Stop. Para. The notification dated 31st July 2015 issued by the Government of Assam, comma, finance within bracket ESTT dash A, close bracket, department, providing for grant of 2 years within bracket 730 days child care leave to women employees of the Government of Assam has been considered by this court. Stop. In the said notification dated 31/7/2015, no, don't say that. A perusal of the notification dated 31/7/2015 would indicate that the decision was taken by the Government of Assam to grant child care leave to women employees of the state government. And on the basis of such decision,
Having minor children.
substitute rule 121 within bracket 2 has been inserted. Stop. The notification provides that women employees having minor children, i.e. up to 18 years of age, may be granted child care leave by the authorities competent to grant leave for a maximum of 2 years within bracket 730 days during the entire service for taking care of up to 2 minor children, whether for rearing or to look after any of their needs like examination, sickness, etc. Stop. Therefore, comma, the grant of such leave to a women employee would relate to looking after the needs of her minor child. Stop. However, comma, such childcare leave cannot be demanded as a matter of right. And an employee, it cannot proceed on childcare leave without prior sanction of leave by the competent authority. Stop. But in the case of Dolly Gogoi, no. In the case of Dolly Gogoi Supra, reference was also made to a judgment dated 24/6/2016, passed by this court in WBC number 2145 of 2016. Wherein it was held as under, you will note from here, A to A, from this judgment. Para. After this court held in Dolly Gogoi Supra, that while the benefit of childcare leave may not be denied to contractual employees, being a beneficial from, comma, having regard to the duration of such contractual engagement, the benefit may have to be granted.
Contextual employment.
The benefit may have to be extended on pro rata basis.
Okay.
So, para. Coming to the present case in here, there's no denial on the part of the respondents that after the petitioner was initially appointed with effect from 5/8/2010. The petitioner is still continuing as a contractual assistant teacher in English in the said Sajini Kanda Higher Secondary School, Barbita. Stop. As already held by this court, that the notification that the grant of childcare leave is a beneficial provision, comma, beneficial provision, and the petitioner having already been granted the childcare leave by the competent authority, i.e., the president of the School Management and Development Committee of the
Sajinikanta Higher
Sajini, what is it?
Sajinikanta Higher Secondary,
Sajini Kanta Higher Secondary School, Barbita,
Borpeta Road, my lord.
Barbita Road. This court does not see any impediment on the part of the principal of the said school to permit the petitioner to join back to her service. Stop. It is also to be noted that the principal of the said school has not filed any affidavit in the present case. Stop. But under the circumstances, as the petitioner has been granted childcare leave with effect from 2/1/2016 to 17/12/2017 on an interval of 90 days period by various orders passed by the competent authority, i.e. the president of the School School Management and Development Committee, comma, this court directs the
Principal.
principal of the Sajani Kanda Higher Secondary School, Barbita Road, Barbita, to permit the petitioner to join back to her service as a contractual employee. No, as assistant teacher in English. As a contractual employee forthwith. Stop. However, comma, para, taking into consideration that the petitioner has not been giving her service from 18/12/2017 till date, comma, till date, comma, the petitioner shall not be entitled to any back wages, to any error salary
For that period.
for the said period.
Well, she will be entitled for salary. And that part will,
That part, I'm not,
There is no prayer on.
with petition is accordingly disposed of with the aforesaid observations. and guidelines.
my lord, any specific time period, my lord,
I said forthwith.
my lord.
It's here.
I am obliged. So.
বেশি কামড়ি না থাকিবে
Yes.
Lordship. Here, my lord, the petitioner, my lord, he has been retired from service on 31st of January 2017. Lordship.
Hmm.
Lordship, Lordship will come to this honorable court's order, my lord. Lordship will be very within short time. Lordship may understand all this fact, my lord. If Lordships come to the honorable court's order, my lord. That is starts from the relevant portion 18, Lordship. 18, my lord. This order was passed on 12/8/2011, my lord. Heard Mr. So-and-so. While working as assistant teacher in Siddheswar ME School, Borpeta, on regular basis, the petitioner was placed under suspension by respondent number 3, namely District Elementary Education Officer, Borpeta District and Masalpur Baska in the month of November 2008, without assigning any reason. Therefore, during the period of suspension, the petitioner claims that the subsistence allowance was not paid to him. On the objection being raised by the petitioner against the said order of the suspension, the same was revoked on 23/3/10, and the petitioner came to be reinstated. The petitioner's grievance is that though he has been reinstated, his salary and allowances have not been paid for the period during which he remained under the suspension, with effect from 17/11/2008 till 22/3/2010, my lord. And he has also not been paid his current salary with effect, that is the salary after he stood reinstated. Appearing on behalf of the respondent number 345, Mr. Das Laner Council so-and-so BTC submits that the delay in repayment of the salary allowances so-and-so has been due to the fact that the headmaster of the said school had not prepared the requisite bill for payment of salary and allowances to the petitioner, but the dispute has now been sorted out, and the payment of salary and allowances of the petitioner would be made within a short period of time. Considering the matter in its entirety and its interest of justice, this writ petition is disposed of with a direction to the respondent, particular respondent number 5, Bodoland Territorial Council, represented by the Secretary so-and-so, to ensure that petitioner's salary and allowances, both arrear as well as current, are within a period of 8 weeks from today made available to him. If for any reason the headmaster of the said school delays the preparation of the bill of the petitioner, respondents, particular respondent number 5, namely Bodoland Territorial Council, represented by the Secretary, Education Department, Kokrajhar, shall remain at liberty to take appropriate disciplinary action or penal action against the headmaster of the school in accordance with law. This is the order of this honorable court, my lord. Now, my lord, lordship will find page 21, my lord, annexure B. And this contempt case, my lord, lordship will find at page 22, relevant portion, my lord. The court's order, when the contempt case was filed, my lord, that has been complied with. Lordship will find at page 22. The explanation given is accepted. The personal appearance of the respondent number 2 is dispensed with. It is submitted by the respondent 2 as well as Mr. Das Laner Council appearing for both respondent 1 and 2, that the order passed by this court on 12/8/11 in WPC has been complied with, and the arrear current salary payable to the petitioner has been paid to the petitioner yesterday on 16/8/2012. In support of such contention, Mr. Das Learned Council has produced the counterfoil of the bank's pay in the slip of State Bank of India dated so-and-so 16/8/2012, showing deposit of rupees 5,31,650 in the account number so-and-so, which is the salary account of the petitioner so-and-so. Now, accordingly, contempt is closed. Contempt was closed, my lord. Now, my lord, in the meantime, when he has been reinstated in service, my lord, on the 20. This is 22, 23/3/10, my lord. He has joined in the post on 23/3/2010, my lord, after being reinstated, my lord. Then, my lord,
Suspension was
made from 17/11/2008, my lord, till 22/3/10, my lord.
Where's the suspension order?
That was the earlier suspension order, my lord, that has not been enclosed, my lord.
Okay.
Now it is not, we are not on this suspension order, my lord. Now, lordship will find subsequently, again, another suspension order was issued, my lord. Lordship will find at page 23, my lord. My lord, this 5th February 2012, Lordship has found it. Page 23, my lord. Number in persons of Secretary BTC Bhai number so and so dated 27 January 2012 and pending drawal of departmental proceedings, Sri Devi Prasad Ghimire, Assistant Teacher, Siddhasar ME School under BO Govardhana of Baska District is hereby placed under suspension with immediate effect. He is allowed to draw 50% subsistence allowance of so and so will, and with the condition that during the period of suspension, he will put signature in the teacher's attendance register from the very beginning and ending of the school hours, my lord. This condition was imposed, my lord. Now, subsequently, my lord, that suspension order has been revoked, my lord. Lordship will find at page 24, my lord. In partial modification of this secretariat letter number so and so, dated 30/5/2013, and in the interest of public service, Sri Devi Prasad Ghimire, Assistant Teacher of Siddheswar ME School, is hereby reinstated and transferred to Madhya Hauli ME School, my lord. From that Siddheswar ME School to Madhya Hauli ME School, he has been transferred. Because of headmastership, my lord, the dispute arose between this the headmaster and the petitioner, my lord. Petitioner claim as a headmaster as a senior teacher, my lord. Anyhow, my lord, the main cause is this, my lord. And he has been reinstated Madhya Hauli ME School in the vacant post arising due to expiry of so and so, so and so, so and so. This order was issued on 3rd of June 2013. Subsequently, my lord, another order was passed by the Director of Education, that is 22nd August 2013, my lord, page 25. As per the approval of Secretary of Education so and so, Sri Devi Prasad Ghimire, Assistant Teacher of Siddheswar ME School in the district of Baksa, is hereby transferred in the same grade and pay posted at Madhya Hauli ME School against the death vacancy occurred due to late Narayan Chandra Das so and so. He is directed to join the school within 7 days from the date of receipt of this order. My lord, subsequently, on the basis of this court's this order of this director, my lord, subsequently he has joined in the post on 10th of September 2013, my lord. He joined on 10th of September 2013, my lord. From 10th of September, my lord, 2013, I got the salary, arrear salary. My lord, now lordship will find next honorable court's order at page 26, lordship. Since I did not get at that time, I did not get the salary, my lord, so I approached before this honorable court, my lord. My lord, only a relevant portion I would like to, my lord, here the para 29, my lord, or may I read all whole, my lord? The page 29, my lord, the second para, the whole basis of the prayer of the petitioner in WPC number 652223, lordship has got it. Siddheswar ME School, they also filed the petition. Is that the petitioner did not attend his duty from 22/8/10 till 9/9/13. That is till he was transferred to the new school. On the other hand, it is the case of the petitioner in the other writ petition being WPC 1802/2014, Devi Prasad Ghimire, that he all along attended his duty but was not allowed to sign the attendance register, which was also the plea in the earlier writ petition filed by him and referred to above. Above being the all disputed question of fact, requiring a certainty of the veracity or otherwise of the pleas taken by the petitioner involved in this proceeding, it will be appropriate for the BTC authority to ascertain the real state of affairs in the matter and then to take appropriate decision in the matter strictly in accordance with law. Accordingly, both the writ petitions are disposed of, directing the BTC authority to resolve the issue as regards payment of salary to the petitioner in WPC 1802/2014, namely Devi Prasad Ghimire, for the aforesaid period, taking note all the attending facts and circumstances in accordance with law. This it was directed to resolve the matter, my lord, by paying the salary, my lord. In the process, the said authority may hear the relevant parties, including the parties involved in this proceeding. Let the required exercise be carried out by the BTC authority expeditiously as possible, preferably within 36/12/14, by passing a speaking order. As regards current salary stated to be payable to the petitioner involved in WPC number 1802/2014. In the new school, the BTC authority shall take appropriate decision immediately, preferably within 10/5/14, my lord, regarding current salary, my lord. That time I did not get the current salary. And page 31, my lord, there was some mistake in the para 29 March 2012. It should be March 2000 instead of 2012. It may be read as March 2010. My lord, I did not get the salary, my lord, this area salary from March. Now, my lord, in the meantime, my lord, page 32, it's an letter by the concerned advocate to the authority concerned for compliance of the honorable court's order and to pay the area salary, my lord. This 32 and 33, my lord. Meanwhile, my lord, when nothing was came out, my lord, then I have this petitioner again approached this honorable court, my lord. Page 34, lordship. WPC number 7383/2017, my lord. And while the matter was pending for about 2 years, my lord, no response came from the other side, my lord, the opposite party. So this honorable court was pleased to pass an order on 25/9/19, my lord. Hard learned counsel for the so-and-so. It has been submitted that the petitioner has received the pensionary benefits. However, as regards the area salary from 23/3/10 to 9/9/13, the same has not been paid to the petitioner while serving as an assistant teacher in Chidesar ME School, Borpeta, along with the revised pay scale and senior grade pay since 2010, my lord. The authority will release the area salary with revised pay scale and also the senior grade pay if the petitioner is found to be entitled after proper verification. This exercise shall be undertaken by the responding authority within a period of 3 months. So this is the order of this honorable court, my lord. Now, this order has been communicated by letter dated 6/12/2019, my lord, and page 37, my lord. And page 38, another letter was written by the petitioner, my lord. Then page 39, this is the communication, my lord, of the district elementary education officer to the director of education regarding this honorable court's order, my lord. Now, in the honorable court's order, my lord, while they communicated the order, my lord, it has been reflected, my lord, this lordship will find at page 41, my lord. In their letter, my lord, that as per record, the petitioner had filed a case number so-and-so before 1802/14 before the Honorable Guwahati High Court for some payment of the salary with effect from so-and-so. Accordingly, a hearing was conducted by the director of BTC Kokrajhar on 24/12/14 for compliance of the order dated so-and-so, 28/4/14. So-and-so, and the director BTC Kokrajhar examined the matter and found that the petitioner had received the area salary so-and-so from 23/3/10 to 4/2/12 by bill number so-and-so dated 36/12, employee ID number so and so for net amount 4,56,227 for 23 months with other two numbers bills 7677 all total 5,31,650 and from March 2012 to 9 September 2013 for 19 months 9 days not entitled for payment as absent on duty, no work, no pay. My lord, this is the suspension period, totally suspension period, my lord. And hence the claim was rejected. The suspension periods, though they admitted the 19 months, 9 days, but it is suspension period and they said that no work, no pay. My lord, when matter is suspended, when the person is suspended, and ultimately again the suspension has been revoked and there was no disciplinary proceeding.
No
pre-
disciplinary
no,
proceeding.
nothing else. And only subsequently it has been revoked and reinstated and I have been transferred to some other schools. Man. Because of the dispute of the headmastership that was already I have submitted before this honorable court that because of the dispute of the headmastership, this cause of action taken against me by the then headmaster. And accordingly, headmaster also gave the note, my lord, regarding my narrativity, all these things, my lord. Now, lordship will find at page 45, my lord. Now, sorry, my lord. Now, 42, lordship. Page 42, my lord, that order has been, my lord, here brought to the notice of this honorable court, my lord. 26 December 2014, my lord. As seen the order dated 28/4/14 of the Honorable Guwahati High Court passed in WPC number so and so, filed by Sri Devi Prasad Ghimire, Assistant Teacher, Madhya Hauli ME School, for payment of salary with effect from so and so. Also read report submitted by the District Elementary Education Officer Baska in the letter so and so, 20th May 2011, and the documents received from the headmaster Siddheswar ME School, Madhya Hauli ME School at the time of hearing held on so and so, 24/12/14 in the office of chamber of the director of so and so BTC. Now, from the report stated above and material available in records, it is found that Sri Devi Prasad Ghimire, assistant teacher Siddheswar ME School, physically assaulted Sri Jagat Bahadur Pradhan, the then headmaster of the said school. Consequently, he was placed under suspension by DO Baska Bhaid order memo number so and so 17/11/2008. And then after the DO Baska reinstated him in service, Bhaid memo number so and so dated 23/3/10. However, he did not report in duty after his reinstatement in service. As the instant petitioner was found non-complying of the authorities' direction and negligence of duty, the BTC Bhaid letter number so and so dated 27/1/12 and this directorate memo number so and so 14/6/14 dated 5th February 2012 placed him under suspension and now he is working at Hauli Madhya ME School as per transfer order. Lordship will note this this suspension order 5th February 2012, my lord. And transfer order issued by the Director of Education, BTC, by order number so and so, dated 22/8/13. The record submitted by the headmaster Siddheswar ME School says that the petitioner had received the salary up to February 2012, amounting to rupees 5,31,650. Only, in spite of the remain absent from duty, the petitioner was unauthorized absent in his duty from January 2011 to 9th September 2013. So far as the teacher's attendance register of the Siddheswar ME School is concerned, the record says that he was not in work from March 2012 to 9th September 2013. Hence, he is not entitled for payment of salary for the period of principles of no work, no pay. This is suspension period, my lord. They have stated, my lord, no work, no pay. The instant petitioner of the case found attending in his duty at Madhya Hauli ME School from 10th September 2013. As such, his current pay bill have been submitted to the petitioner, to the Secretary BTC by the BO Govardhana for the period with effect from 10/9/13 to November 13, and the same is under process to pay soon. After consideration of the case, the claim of the petitioner is prima facie does not seems to be adequate as reports of the concerned district authority and headmaster of the schools who is allowable for arrear salary with effect from 10/9/13 to November 2013, and hence his claim for payment of salary with effect from 23/3/10 to till date is herewith rejected, having no merit, non-ist as per rules. This is issued in tune with order of 28/4/14 of the Honorable Guwahati High Court, passed in WPC number so and so. Now, since my lord, in this case also, they have admitted, Lordship is writing,
Yeah, 5 minutes.
December 2014, page 42, my lord.
Ah.
They have admitted that this 19 months, 9 days salary is
That
due
is from the period?
as per their this 5th February 2012, my lord. Since it was issued on the basis of the letter dated 27/1/12, my lord. And ultimately it was issued on 5th February 2012, and petitioner joined in service in the as per the order of the secretary and the director, my lord, on 10th of September 2013, about 19 months, 9 days, my lord. That suspension period, my lord, that suspension period, now they want to say, since you did not work, that is why no work, no pay. They have admitted 19 months, 9 months, or 9 days. And so, my lord, since in the suspension period, my lord, no departmental proceeding, nothing else was there. And once he has been reinstated, meaning thereby the admitted position by the respondent itself for 19 months, 9 days is admissible under the FR and under the settled laws of this honorable court. My lord, meanwhile, my lord, this this page 43, my lord, this time scale, my lord, this time scale, oh no, this is 43, my lord, 9/11/20 prayer for providing a copy of the office order so and so issued by the Director of Education Officer BTAD. My lord, in earlier occasion, though I filed the writ petition, my lord, wherein this order could not be brought to the notice of the honorable court. And subsequently, when I got the order, my lord, and pen and paper, my lord, in earlier occasion, it has been shown in the official documents that I received it. But subsequently, by this page 43, I got again this order. I obtained the order from the authority concerned, 26/12, and I have come before this honorable court. Now, page 44, my lord, time scale. Time scale also, page 44, my lord. Time scale also not been paid, my lord. In the service year, my lord, as a whole, 3 times, my lord, the time scale is fixed, my lord. 3 times as a whole. That has not been paid, my lord. And they will calculate, my lord, when lordship will pass the appropriate order, the time scale will be paid by them. Senior grade pay and a revised pay scale, my lord. Now, my lord, they have filed an affidavit, my lord. And to that extent, I have also filed a reply. Only even in 2017, when the matter was pending before this honorable court for 2 years, my lord, this BTC never responded, my lord. They have not filed any affidavit. And accordingly, court passed the order, my lord. Now, my lord, since it has come to my knowledge, my lord, notice, my lord, so I have come before this honorable court challenging this order also. And this ROP, revision pay, my lord, though it has been prepared the bill, and it was sent to the authority concerned. But it has not been paid as on today, my lord. About 77,000, my lord. In their affidavit, my lord, the government affidavit lordship will find at page at para 10, my lord, of the government affidavit, BTC's affidavit, my lord. The serial date तुम्हारे को 9 क्यों? Oh. Para 10 of the affidavit filed by the BTC, my lord. That as regards the statement made in paragraph 7 of the representative, the answering deponent Bexley reiterated and statement made in paragraph 9 of the incident affidavit in opposition. The answering deponent further stated that the writ petitioner has already received the arrear and revised pay scale as per ROP 2017 amounting to rupees 77,920 rupees. My lord, now in the reply I have categorically denied, my lord, though that the amount has been prepared, but it has returned back. It has not been paid, my lord. Now, as a whole, my lord, here, my lord, this petitioner, my lord, this arrear salary for my lord, as per my this petitioner's claim, my lord, the arrear salary due to the petitioner from 23/3/2010 to 9/9/13 for 42 months, my lord. Now, out of that, out of 42 months, my lord, they have admitted that for 19 months, 9 days, he was remain absent, remain suspended, and that is why no work, no pay will be applicable, and salary has not been paid this month. Now, my lord, lordship is aware about, as per this FR, my lord, FR 54, lordship.
Give me a fuck. FRC.
54B, page 127, my lord. Down below, my lord. 54B.
FR
54B.
54.
B. In my book, 127.
Yes.
My lord, may I read, lord? when a government servant who has been suspended is reinstated or would have been so reinstated but for his retirement on superannuation while under suspension, the authorities competent to order reinstatement shall consider and make mention. Now three, my lord.
Hmm?
Three. Lordship has found
Hmm.
3. 54. Where the authority competent to order reinstatement is of the opinion that the suspension was wholly unjustified, the government servant shall, subject to the provisions of Sub-Rule 8, be paid the full pay and allowances which he would have been entitled had he not been suspended, provided that where such authority is of the opinion that the termination of the is not necessary, proceeding initiated against the government servant had been delayed due to suspension. But these three, the provider is not necessary since I have not been terminated. Where the authority competent to order for reinstatement is of the opinion that the suspension was wholly unjustified, the government servant shall, subject to the provisions of Rule 8, be paid to full pay and allowances which he would have been entitled had he not been suspended. So, my lord, as per these provisions, my lord, I'm entitled once I have been reinstated in service. And my lord, since in the case of this lord, short judgment, my lord, I would like to rely on. Raj Narayan, my lord. 2019 5 SCC 809. My lord, the relevant para, my lord, I would like to, so my lord, para 7 and 8 lordship. The point that remains to be considered is whether the appellant is entitled to payment of full wages between 1979 and 1987. The appellant was placed under suspension on 23/10/1979 and his suspension was revoked on 21/10/1987. An interesting development took place during the interregnum by which the disciplinary proceedings were dropped on 21/3/1983. It is clear from the record that the appellant was the one who was seeking postponement of the department inquiry in which of the pendency of the criminal case. The order of suspension was in contemplation of disciplinary proceedings, by which, by virtue of the disciplinary proceedings being dropped, the appellant becomes entitled 28/9/2002. But it is the NIT who refused the petitioner to perform their duties up to 62 years. We do not find any fault on the part of the writ petitioner in not attending their duties, and rather they were not allowed to perform their duties by the institute. That being the position, the principles of no work, no pay cannot be made applicable in the present case. In this connection, reference may be made to the decision of the apex court in J.N. Srivastava versus Union of India, so and so. So and so UPSRTC Limited. 10, my lord. We are therefore of the view that the learned single judge was not right in observing that the writ petitioner would not be entitled to back wages by applying the principles of no work, no pay. Hence, it is directed that the writ petitioners would be entitled to all service benefits, including the back wages up to 30/9/2004 and 31/12/2004 respectively. That is the dates when they attain the age of superannuation, that is 62 years. The next question which requires determination is who will pay such back wages of the writ petitioner. That part, my lord, not necessary. This is the case where
Yes.
so, my lord, here, my lord, when the position is admitted by the respondents authority themselves, that for suspension period from 5th February to 10th of September 2013, 10th September, I got the salary up to 9th September, my lord. So 19 months, 9 days, my lord, as per their calculation. That part I was under the suspension, and that no departmental proceeding, nothing else, my lord. And thereafter, I have been reinstated by the authority concerned. So where is the question of no work, no pay? And where is the question of denying of the arrear salary, my lord? That part. And other part, my lord, for 42 months, which I claim, my lord, since I joined on 23 of March 2010 after being reinstated in service, and I continued my duty, my lord. But the authorities, my lord, did not allow me to put my signature in the attendance register, and thereby whole report was sent against me, and thereby it was presumed that
There's a statement in paragraph 9 that you have been paid the arrear salary from 23/3/2010 to 4/2/2012
which one, my lord?
in the affidavit in opposition.
This is 12, my lord. They have stated in their affidavit, my lord. Paragraph, my lord.
9.
9, yes. Yes. That as regards the statement made in paragraph 6 of the answering the opponent begs to state that as regards to the claim of the writ petitioner for arrear salary from 23/3/10 to 9/9/13, 42 months, the answering the opponent begs to state that the writ petitioner has already drawn arrear salary for 22 months, 13 days for the period from 23/3/10 to 4/2/12. My lord, the arrear salary, my lord, let them produce the acquaintance register, my lord. My lord, since I was under suspension, my lord, since 2008, my lord, and up to 2010, my lord. That period suspension, the allowance were not paid, my lord. And when I came, and that subsequently he has been reinstated, and the salary was not paid, arrear salary was not paid. So I approached this honorable court in 2011, my lord, by virtue of which the honorable court's order, my lord, they paid the whole arrear amount for the said suspension period and all, my lord. Now they have said that from 23/3/10 to 4/2/12, they have said that they have paid. I said no, I have not been received. Even, my lord, suppose as per this calculation, their calculation, my lord, I mean, as your lordship said, up to 4/2/12, they have paid it. Suppose. My lord, what about after 5, my lord?
No, that they are disputing. That
Yes.
they are disputing. But for that period,
This is I'm disputing. Even then, my lord, now, my lord, since 23/3/10 to 4/2/12, my lord. I was there, my lord, and this amount I have not been received. So, in the honorable court's order, first I have shown, my lord, before lordship's, my lord, and this total amount which I receive in the contempt, my lord, contempt case, my lord, lordship will find the contempt case, my lord, it was closed on (17/8/2012). Even for my lord, now at this stage, my lord, since the person is about 67, 68 years, my lord. Now, my lord, he has no such, my lord, is very much now very ill person, my lord. Even then, whatever, my lord, the admitted amount, whatever it is, apart from this disputed amount, whatever the admitted amount is there, my lord, let them pay.
What admitted amount?
That from the day of this suspension, my lord,
5/2/2012
lordship,
up to
up to 9/9/2013, my lord. Up to 2012, in reference to the director's order 27/1/2012. So totally, as per their admitted amount, 19 months, 9 days, my lord. Even not for, if lordship will not go for 42 months, even for 19 months, 9 days, my lord, at least the suspension period amount is entitled by the petitioner, my lord, along with the time scale and senior grade pay scale, all this, my lord. And the rest of the part, my lord, which I, my lord, prayed for before this honorable court, this from 23/3/10 to this 4/2/2012. They said that already it has been paid. Let them examine and they will pass accordingly. If it is paid, they will furnish the report accordingly and by calling the petitioner. And rest of the part, they have admitted that it has not been paid. They will pay it. That's all, my lord. Otherwise, if we go on, my lord, then again, matter.
yes, Bora.
But will straightway come to the prayer of the petition.
That I've seen.
Only challenge to the order dated 26/12/2014.
26/12/2014.
That is page number 42. But we have gone through this order. There is no work, no pay from the period 23/3/2010 to 9/9/2013. This order was passed on 26/12/2014. And this order was never challenged by the petitioner in the earlier petition when the order was. He also filed a case in 2017. It was never changed. But now he has come in the interpretation that this order was not furnished to him. So in 2021, he is coming and challenging this order. All 7 years, he was sitting over it. Lordship will find, my lord, my affidavit, Lordship will find. I'll show it, and my lord, this order, my lord, S42, Lordship will kindly turn to page number 42. What this order was furnished to him And last line, my lord,
1
See.
minute.
42 one.
Hmm.
Last line, my lord, OP2, the petitioner, 8. And all along the petitioner, he says this was not furnished. That's why now in 2021, I am challenging the order of 2014, that is 26 December 2014. What will take off my affidavit.
Hmm.
And lots will turn to page number 12. I have annexed the particular order. Page number 12. He has said, all along I have not received it. I have received it in a RTI. Lots will see down below the signature of the petitioner. He had received it. And I am not selling this order in 2024. He's sitting all along. His signature is there. On affidavit, I have stated that he had received it and a signature was there and he's sitting over it. And 2021, suddenly he writes, as I'm saying, and starts challenging, file a petition challenging it, my lord. That's why, my lord, my stand in the maintainability part, my lord. He has not come in the people of gone with clean hands. Even if he has received it, he has not challenged it. So my first maintainability is that this particular order which he had received in 2014, he had not challenged it. And now only in here, in order to delay, my lord, there is in challenging this order. This is the three mentality ground I have given, my lord. And now coming to one is he has not approached the claim with clean hands because he have all along he has said that he has not received it. In fact, he have received it. And a delay of more than 7 years, my lord, in challenging this order. 2014 order, he is challenging in 2021, saying that he had not received this order. Delayed. Lordship will say, and my lord, Lordship will see the suspension order, my lord. Suspension order in page number 23 of the 8th petition. Suspension order, that is dated, page number 23, my lord, of the 8th petition. That is dated when the 5th December 2012. Second paragraph, my lord. This person is suspended. He is allowed to draw 50% subsistence allowance under FR Rule 53(1)(a) with the condition that during the period of suspension, he will put signature in the teacher's attendance register from the very beginning and the ending of the school. This was never challenged. This suspension was never challenged. And not even today, it is under challenge. And thereafter, he was reinstated. He said thereafter, he was reinstated. This suspension order is gone. In fact, my lord, you'll turn to page number 24. Next page, my lord. In the very first line, it is in partial modification. In partial modification, the secretary order so and so, that earlier order, my lord, and the secretary order so and so, and in interest of public interest, the so and so assistant teacher of so and so school is hereby reinstated and transferred. This is not that suspension order has not been modified, totally modified. Partial modification happened, and then he had been accommodated in the reinstated in and transferred to another school. So this condition was there, and this never challenged. He never, because of the ultimately, my lord, he has now if he is challenging an order of 26/12/2014 in 2021, where we had made it absolutely clear, my lord, that the period from 23/3/2010 to 9/3/2010, he was never signed he was never attending the school, never signed a. That's why that because of no work, no pay, this person, that amount has not been released.
Yes,
And
Chetri.
there are two things. Well, another two
One
things.
minute, I'll come back to you. What is this annexure to page 12 of the counter affidavit?
It's page 2.
Annexure 2 of the counter affidavit.
Thank you.
Yes, that has been, my lord, under challenge, my lord.
That is under challenge.
Yes.
But then you said that you will not furnish a copy.
Yes, my lord. That, my lord, pen and paper, it has been shown in my reply I have given, my lord.
No. That I've seen, that after the order was passed.
Yes.
You made your application on 9/11/20.
Yeah.
2020, correct? The order of 2014,
Yes.
you made your application in the year 2020, saying to give him a copy.
My lord,
But then in their annexure,
Yes.
annexure 2, you have received a copy on 7/1/2015.
no, yes, that in 15, my lord, this pen and paper I have admitted. The in pen and paper I have been signed. But that particular order was not furnished to me, my lord. They have obtained the this in the peon book, my lord.
No, it's here.
Whatever,
Annexure
yes.
2.
Yes, it is. They have furnished me, my lord, this book, my lord, and I have been told to sign, my lord. And accordingly, my lord, this copy I did not get, my lord. Had I get this particular order, my lord, I would have challenged in 2017 itself, my lord. Since I filed the repetition in 2017, my lord,
Chetri,
lordship,
the order of 26 December 2014,
lordship.
you say you did not get, correct? In the witness of the headmaster of the school, you signed in this document on 7/1/2015,
Yes, that
correct?
yes.
So on 7/1/2015, at least you had the knowledge that this order was passed.
My lord, this order was passed, my lord. I have not been, my lord, I approached. And I have been told that all the time that you will be furnished the copy. That,
You've, according to you,
yes,
after 2014 order was issued, you were not served a copy, correct? Then your first representation was in the year 2020.
my lord, since this copy, my lord, I did not get, my lord. That is why I again, my lord, on the basis of this, my lord, I have come to know that yes, there is an order. So I applied, my lord. That is why, my lord,
In the year 2020,
yes,
you
I
applied
applied.
in the year.
Yes.
What about this annexure 2 of the counter affidavit?
This applied, and accordingly I got this order, my lord. Annexure 2. Annexure 2. I got this.
Have you seen the bottom part of that annexure 2? Your signature is there.
Yes.
It's of 7/1/2015.
It is obtained by them, my lord, in the order.
That's why you signed it
I signed it in the order.
in the year 2015.
15.
So you were aware that in 2015 this order is there.
This
Why
is-
did you apply
yeah.
only in 2020?
No, my lord, since I didn't have this copy, my lord. I signed, my lord. I didn't have the copy, my lord.
It's difficult to digest that submission, Mr. Chetri.
And
I
that
think
and-
you are coming with
and that apart, my lord.
unclean hands.
I-
You are trying to mislead this court.
No. And
Plus, you are suppressing facts.
no, my lord. That
On that ground, I think writ petition will have to be dismissed.
no, my lord.
Maybe you have a good case, but on the ground of suppression, writ petition will have to go.
No, my lord, since though I have been told, my lord, I'm really sorry, my lord.
See, order of 26 December 2014 was shown to you. You put your signature on 7/1/2015 in this order itself, in the presence of your headmaster. In the presence of your headmaster. Then you say that you did not get a copy, so you applied in 2020.
No, sir.
At least the knowledge that this order was passed, you had it on 7th of January 2015. That knowledge was already there. Supposing, assuming, but not admitting and accepting your submission that on 2015, this order was not given to you. But then you had the knowledge, and therefore the next day you could have applied.
Yes, that is why, my lord, to apply, my lord, it has been delayed by the petitioner, my lord, to apply. So, my lord, only he had the knowledge, my lord, that order was passed. But
Then why did you apply in
it has
2020?
it has been delayed to apply, my lord. That is why, my lord.
And
Extremely sorry, my lord, for
and
that.
before applying, you had already approached this court earlier.
My lord, since
You had already approached this court earlier.
my lord, probably, my lord, my lord applied.
Don't come with probably, maybe. Don't
No.
give this submission.
My lord, since it has been applied in 2020, my lord, and
Now-
had it been applied in earlier, then certainly I would have before the honorable court in 2017 itself by this impugned order.
Earlier, you had approached this court.
Yes,
Which writ petition was that?
lordship will find.
What will turn to page number 18. This is writ petition number
And it was
119 of 2010. He is a very vigilant person. He comes with a writ petition each and every time.
No.
First writ petition.
No. After you pass this order,
After you pass
Lord-
it, Lordship will turn to page number 34. 2017. 7383 2017 is a writ petition. Page 34 of the writ petition.
in 17, my lord, I filed, and in 19, after 2 years, case was pending. After 2 years, it was disposed of, my lord. But the respondents also did not come with the clean hands, my lord, saying that there is an order, my lord. Respondents did not come, my lord, for 2 years. They were sleeping over the matter, my lord. Had there been, certainly on the then that, my lord,
2017, when you filed this writ petition,
my lord.
you already knew the existence of the 2014 order.
My lord, 2014 order, my lord,
Mr.
since
Chetri, I think
sin-
we have wasted enough time.
the lordship will find my reply, my lord. I given the reply, my lord, properly. And my lord, there is a gap of suppose for challenging this order, my lord. For about 6 years, there had been lapse, my lord.
I'm not going to the lapse of the period. On 7/1/2015, you put your signature on this order in the presence of your headmaster. That day you knew that this order was passed. Then you come to court in the year 2017 by suppressing the fact that this order was already there. This court passed this order. And after that, in 2020, after 5 years, you approach the authorities, give me a copy of that order of 2014.
My lord, that part, my lord, since my lord, as per the petitioner's contention, my lord, though he has been allowed to sign in the orders itself, my lord, it was not furnished, my lord. That is why, my lord, he thought that it would be supplied to him, my lord.
That's right. That's the question I'm asking you. Assuming that you were not given the copy on 7th of January 2015, but then you already knew, because you already knew the existence of this order, because you signed on top of this order. You signed on top of this order. You could have applied for this copy the next day.
Yes, my lord,
And
that
then when you came to court in
yes, my lord.
2017, you could have annexed that copy.
There is a lapse, my lord, on the part of the petitioner, my lord. He has not applied.
No, not lapse, but suppression of material facts.
Not that, my lord.
No.
Otherwise, I would not have come before lordships, my lord.
What I can do, I can give you time to take instructions.
Lordship.
I'm not dismissing your writ petition. Next day, after instructions, you are permitted to withdraw this writ petition. Or I'm dismissing this writ petition on this ground alone. If this order of 2014 was actually not given to you and not known to you, you have a good case. But you had the knowledge. And you suppressed that fact in year 2017, as well as in this writ petition. For 2 times, you're trying to take this court for a ride. First time you were successful, but this time, unfortunately, you are not successful.
My lord, only,
What do you want to do? You want to withdraw or dismiss?
since lordship has said to get the instruction, my lord,
Then don't argue anymore.
to get the instruction.
I've already given you 1 hour time. If you want to take instructions, you come back. But this case, I'm noting it down. If you don't withdraw the next day, I'm dismissing it.
Yes.
On request made by Mr. P. Churchill and counsel for the petitioner. Please the matter again on 14th August, no, 13th August,
Not 13, my lord, 14 lordship.
on 14th of August. To enable him to receive instructions.
Lordship.
Also heard Mr. S. Bola, then a standing counsel.
Lordship will keep it part heard, Lordship will heard everything.
Yes, his lordship will be available, yes.
I'll be there.
Lordship. Okay.
Ray,
I'm sorry, my lord.
No, I'm not blaming you. But your client. There's some mischief is trying to play with the court.
Lordship, this matter taken up any other lordship, this is pay go is paying lordship, he's some person defense to the lordship.
No.
Can I call it upon?
No.
I told,
I will contact the case, lord.
Hmm?
I will contact the case, lord.
He's conducting the case.
no, not he, K Gogoi lord,
Either miscommunication.
Oh,
K Gogoi.
K. Gogoi.
He is paying for on behalf of the higher education lordship, technical. He has some personal problem
So,
lordship.
but there is some urgency, lordship. Urgency is the that lordship.
Any other day lordship.
Let me say.
Only
Lordship, in
he-
2021, government has taken a decision to enhance the remuneration who are serving in engineering colleges. And my name is also recommended. Even after recommendation and approval, I am not allowed to have the enhanced rate of remuneration. That is my first argument of contention, lordship. Secondly, lordship, so far the qualification, they have given a contrary view. The affidavit filed by the director technical this time, but while the recommendation was made by the same director of technical education, saying that I have fulfilled the eligibility criteria as prescribed by the AICTE norms. So let the matter me adjourn, but so far the my remuneration. Lordship, kindly for have a look page 52 annexure 21. Page 52 annexure 21. Since 2001, I have been appointed in 2011. Thereafter, I am continuing in service in Jorhat Institute of Science and Technology. And then thereafter, government has taken a decision to enhance the remuneration, lordship. Ultimately, this order was issued. Page 52 annexure 21.
Okay,
This
but if Gogoi wants a bit, we'll give a fixed date.
Yes,
on a hearing day, lordship.
yes,
Third, they call on counsel for the petition on request made on behalf of Mr. K. Gogoi and the standing counsel higher division. When?
Next week, lordship, on a hearing day, okay? Next week, Tuesday or Thursday. Get it, they're eligible.
Thursday, we are celebrating Independence.
Sorry,
Day.
sorry, I'm so sorry. Then after, can it be on 20th?
yes.
20th of August, 23rd.
for
So there's an interim order that may be.
Oh,
30th.
interim order passed already.
Or is also I am afraid.
Here in this, we have filed our affidavit, so we have loss of file, so we have to reconstruct lot. And some. Everything.
On a hearing day, lordship.
How did
They
you
hold
lose your
matters.
files?
They have filed reply, we have filed our replies.
Everything.
They are not.
38 acre land council for petition.
Okay, no.
On request made by S. Buyan and its standing council,
Higher.
higher education. When?
27 lots. And they were to dispose of the matter. It's a very old matter, 21 matter. I'm sorry.
Five.
Where is your lordship?
Mm.
Lordship, kindly some time may be allowed, my lord. We have received instruction, madam. So kindly.
So affidavit is not required, let's say, because let's say kindly have the impugn order. On many occasions, the matter has been listed. Our grievance is that claim is that since I am serving as a casual employee, I am entitled to have the minimum pay scale. This is second round of litigation, lordship. In the earlier round of affidavit, they cannot change because already they have come up with a decision that since I.
Anyway, later file your affidavit, later get your fees, isn't it? That's the reason you want to file your affidavit.
Already man retired after rendering
But I'll give you a short time.
35 years of service, lordship.
But they call and the council on request made by MS N. Spoken, then the standing council,
Elementary.
elementary education, list the matter on
On 28, lordship.
Yes, madam.
28. I never heard.
Sorry, on not on 28, 27th lodge, on a hearing day lodge.
Yes,
And
madam.
last time, lodge, already they have.
Okay, don't say like that. Heard a deka, then the council for the.
Agency is there. lodge.
Mr. MS N. Fukan and the standing council, secondary education department, submit CS receiving instruction. And place for weeks time to file the same, praise a lot. It's done.
27th of
27.
August.
Six.
Apply.
May it please the lordship. In this instant case, the law is settled by the Supreme Court with respect to the similarly situated.
Elementary. Only question that this court wanted to know was whether the termination order was served on the petition.
No, the instruction is on record. There is an instruction which was submitted, your lordship.
Where's the instruction?
It was a bunch, a set of bunch, it was submitted, your lordship.
No.
I may just pass over mine one, your lordship. The lordship will kindly have it. This was submitted by them, your lordship.
Instruction.
Termination করেছেন নাই করা termination So this termination order was never served on us. And to that extent, in Dulu, Decca, the similarly situated petitioners, the Honorable Court has said that if the termination order was not served, then you have to pay the salary for that period for which the service was rendered.
Wonderful.
Met me, the Lordship.
You will take up at two.
Yes, your lordship. In the meantime, I'll make a
With due
copy of this.
permission, my lord, may I mention item?
You are appearing in this matter.
Hello.
also. You have this copy.
No, I'll just go through it.
Okay. You just. Yes.
Because last week I was running fever, my lord.
Ah.
So if your lordship can take up item number 11 after this matter, otherwise it has to be adjourned because I'm not feeling well. my lord.
What happened?
I was running fever last week for one week.
You're
That's why
you're still having the
Fever.
fever.
I was running fever. So today I'm thought that it will be over by lunchtime. So if your lordship can take up after this matter at 2, or my lord, it can be adjourned to next Tuesday or Thursday.
On request made by myself, cycle.
I think we'll do
This the matter of 13th.
13th of like 6:30.
Oh.
The similar writ petitions were also dealt with.
Yes. I got it.
The similarly situated writ petitions was dealt by Supreme Court. And the Supreme Court, the matter was set as pressed. It was Dulu Devi. I may place your lordship the judgment. One lage.
No, my pick up lunch.
Okay.
Photo give.
If your lordships kindly turn to page. The judgment starts at page 39, your lordship. I'll read from para 6, your lordship. Para 4, basically, page 43. May I read, your lordship? The petitioner joined the respective post immediately after the appointment in the year 1999. In this case, I was also one of the petitioners. But the respondent did not pay their salaries. Thereafter, the petitioners number 1 and 2 of such and such approached the court by such and such for payment of salaries. The court passed orders dated such and such, respectively directing the respondent authorities to release the salary. Accordingly, all the LP school assistant teachers appointed in the year 1989 were given their salaries. The petitioners continued to receive their salary till July 2007, but the same was stopped thereafter. On inquiry, the petitioners came to learn that the Joint Secretary to the Government of Assam Education Department had issued a letter dated 9/2/2007 to the Director of Elementary Education, Assam, directing him to stop the reported roll of salary for 193 terminated teachers from the government exchequer and to take necessary steps for recovery of money drawn by 193 terminated teachers, which includes the petitioners. The letter dated 9/2/2007 also directed the Director of Elementary Education, Assam, to ensure that the terminated teachers, which included the petitioner, should not be allowed to work any further, and their services should be treated as if they were never in service, as they have been terminated with effect from 18/5/1992. Thereafter, by communication dated 7/3/2007 issued by the District Elementary Education Officer Dhemaji and communication dated 4/5/2007 issued by the Director of Elementary Education Assam, the petitioner's salary was stopped with effect from August 2007. In this context, we have approached this honorable court. Number 7, the petitioners have by way of this present petition prayed for a direction to release their current and arrear salaries with effect from August 2007 on the ground that they were still continuing in service. No salary is being paid to them. The petitioners have also prayed for setting aside such and such orders. Now, if your lordships kindly come to para 9, that page itself, page 44, down below, para 9, the last paragraph. The petitioners have also relied upon the decisions of the Honorable Supreme Court, passed in this case of Dulu Devi versus State of Assam, to submit that the petitioners herein are similarly situated and the decision in such and such is applicable to the petitioner's case also. Now, your lordship will kindly turn to page 46.
10 and 11 were the submission made by the Education Department. Page 46, para 12. I have heard the learned counsel for the parties. Have your lordship got it? In the case of Dulu Devi and state of Assam, the division bench of this court by judgment dated such and such have held that the service of the petitioners whose service was terminated by an order dated 18/5/1992 had no legal right to continue in service beyond the year 1992. Accordingly, the petitioner Srimati Dulu Devi was not entitled to any similar salary. The division bench in order dated such and such has recorded the fact of the said case pertains to the appointment made in Dhemaji subdivision district. Para 6 of the judgment is reproduced herein below. Now your lordship will turn to next page, your lordship. Here 193 petitioners are terminated and I was one of them. But I was never terminated. That isn't alleged. Down below, your lordship, the findings of the division bench in Dulu Devi. As the case was dismissed by the division bench of this court, Srimati Dulu Devi filed an SLP before the Supreme Court in case of Dulu Devi versus State of Assam, such and such. It has been reflected in para such and such are as follows. Learned counsel appearing for the appellant submits that the appellant has never been terminated from a service and that no order of termination has been ever served upon her. This is my specific case, and the instructions also said that there is no record of serving any termination order upon the petitioners. He further submits that without going through the relevant records and files, the respondent authorities prepared a list of 193 teachers and included the name of the appellant for terminating their services. Indisputably, the appellant has been paid the salary by the respondent authority for at least 25 years without serving any termination upon her. Now, I'll skip para 11. Para 12. Learned counsel appearing for the respondent submits that the respondent authority terminated the services of the illegally appointed teachers, including the appellant, but they were continuing in service and drawing their salary till 2007. However, the salary was stopped with effect from August 2007. Thus, the appellant's salary was also stopped as she was appointed illegally and her service was terminated in 1992. He further submits that the High Court was rightly held that if the service of the appellant stood terminated in the year 1992, then she has no legal right to claim salary, regularization, promotion of services as the relevant materials were not produced before it when the earlier order was passed by the High Court directing the respondent to release the salary and allowances to the appellant and also to make an inquiry with regard to the claim of the appellant for regularization. Now the finding of the court, your lordship, para 15. In our considered opinion, the approach of the High Court is not in accordance with law. The services of the teachers who have been working for the last 25 years shall not be assumed to have been terminated and deprived of our legitimate claim. The Constitution Bench of this court in case of State of Punjab and Amar Singh Harika, reported in year 1966, page 1313, considered the aspect of the matter. Writing this judgment, his lordship held that mere passing of an order of dismissal of termination would not be effective unless it is published and communicated to the officer concerned. I'll pause here for a moment, your lordship. The bunch of instruction which was placed by my learned friend, the page 4, if your lordship kindly peruse that, the fourth para, page 4, the fourth para from Mohendra Sharma, that sir, there is no such record of receipt of termination order by the petitioner. They have categorically admitted that.
Yes.
If the appointing authority passes an order of dismissal but does not communicate to the officer concerned, theoretically, it is possible that unlike in the case on a judicial order pronouncement in court, the authority may change its mind. Now, I will not read this other similarly opinion. Now, lordship will come down below para 15. Upon hearing the rival contention and after going through the order of learned single judge in question, it is admitted fact that all the respondents in the appeals are continuously working as teachers and their salaries are being paid by virtue of court's order. Arrear salary from July 2007 are not being paid. When the respondents are continuously serving as a teacher, the question whether they are illegally appointed or otherwise, it matterless. However, for the services rendered as by private respondent and availed by the state, on the principle of quantum merit, the salaries have to be paid. In that view of the matter, we find no ground to interfere with the order of the learned single judge. Accordingly, the appeals are dismissed. In view of the apex court, order of the apex court in case of Dulu Devi versus State of Assam and the judgment passed dated 19/3/2015 in such and such, I find the petitioners, if they are still in service, are liable to be paid their salaries for the period of work done by them subsequent to July 2007. Accordingly, the petition respondent shall examine whether the petitioners have been worked subsequent to July 2007 in their respective schools. And if found that the petitioners have been working in the schools beyond July 2007, the petitioner should be paid their salary for the work done. It is also made clear that until the questions of whether the petitioners have been appointed illegally and irregularly is decided by the respondent authorities, the service of the petitioners who are working should not be disturbed. The petitioners who are found to be working subsequent to July 2007 should be paid their salary on the principle of quantum merit as held by division bench of this court. The arrear and the current salaries of the petitioners who are found to be working should be paid within a period of 3 months. Now, Your Lordship, I am claiming my salaries beyond 2007. That is from August 2007. And after this judgment, this was the finding. The instruction has been laid by them before this honorable court that the service of that there was no service of termination order upon me. Now, if that be the case, Your Lordship, I am covered by Dulu Devi case passed by this honorable Supreme Court, wherein they have stated that merely passing an order is not sufficient. That has to be communicated to me. And recently, Your Lordship, on a similar line,
Yes.
I'll just read the operative portion, Your Lordship. Para 14, page 625. This case also relates to the Hemaji and the same set of petitioners. In our considered opinion, the approach of the High Court is not in accordance with law. The service of the teachers who had been working for last 25 years shall not be assumed to have been terminated and deprived of a legitimate claim. The Constitution Bench, I'll skip this because this is the observation. This Constitution Bench judgment of this court in state of Punjab and such, consider this aspect of the matter. Writing the judgment, His Lordship, that mere passing of an order of dismissal or termination would not be effective unless it is published and communicated to the officer concerned. Now, Your Lordship, the para 17. In the background of the facts of the case, particularly the continued service of the appellant for the last 25 years, the impugn order passed by the High Court cannot be sustained in law. For the aforesaid reason, the appeal is allowed. The impugn order is set aside. Consequently, the appellant shall be entitled to continue in service and further entitled to all area salaries in accordance with law. This was the view that was accepted by this honorable court while passing the judgment. I've just read it now, which is annexed by the honorable single judge. And in that view of the matter, after the filing of this case and after filing of after the judgment was delivered by the honorable single judge, they come up with that plea in their affidavit as well as that instruction that was never communicated to me.
That's fine.
So
The
in
termination order.
Yes, Your
In
Lordship.
this writ petition, you are impugning the
In this case, I am impugning, Your Lordship, the salaries which has not been paid to me since August 2007 till 2021. And precisely when the matter was heard on 21/6/2024, after passing of this, after submitting all these instructions, that was also an observation made by the honorable single judge also on that day.
How about this order, page 53, annexure 11?
Your Lordship, they say that they have appointed me as a tutor. Now, my question is that when I was never terminated from my job, how could you have appointed me as a tutor? Of course, I must honestly and candidly admit that, yes, I'm working in the same school, but as a status of tutor. But how can you convert my appointment? And that was the precise question been asked by the honorable single judge. If he is illegal, how could you have appointed him as a tutor? There was no answer to that. They appointed me on 30th January 2021.
So September 2000, August, from September you're asking,
Yes, your lordship.
September 2007
Para 11.
to
Till
January.
date, your lordship, because I filed the case on 2022. That is 15 November 2022.
No, till date, you're not getting your salaries.
I am getting only 10,000 minus 500. Whereas my scale of pay should have been 40,000. That's what in Dulu Devi they have stated.
When are you getting, since when you are getting 10,000?
Your lordship, since 30th January 2021, after my appointment, your lordship, it's since 1st February 2021. However, in Dulu Devi and the order passed by the Honorable Single Judge, that is Justice Michael, they have said that you make an inquiry. If the termination order was not served, you pay them the full salary. They'll be deemed to be in service. And it's my admitted case that I have been rendering my service in the same school. Only to wash off their hand, they have issued this order to appoint me as a tutor.
So you want this set aside?
Naturally, this will go and my status as assistant teachers should be restored.
Yes.
And I have to be paid my salary.
Well, the prayer in the repetition, what my friend is saying is contrary to the prayer that is made in the repetition. Page 11 is the prayer, madam.
Yes.
He is claiming salary from September 2007 till 29 January 2021. And the reason is, my lord, page 53 is the order that is passed on 30th January 2021. Lordship finds the prayer in the repetition at page 11.
Yes.
He claims it for till 29th of January 2021 because 30th January he was accommodated as a tutor by order dated 53.
Page 53.
Page 53. ma'am. Now the moment he accepts this order, madam, page 53, he has joined pursuant to this order. He has accepted this order and there is a condition in the order, madam. Your lordship will kindly read page 53. May I address? In exercise of power conferred upon the Director of Elementary Education by letter dated so-and-so and in pursuance of government approval communicated dated so-and-so and subject to satisfactory police verification report and production of physical fitness certificate from the concerned Joint Director of Health Services, the following candidates hereby accommodated as tutor in LP upper primary school on purely temporary basis in a fixed salary of so-and-so under the as per the Assam Education Provincialization of Service of Teachers and Reorganization of Education Institution Act 2017 under Deputy Inspector
No,
of
that's
School.
why.
Yes,
This is under challenge.
my lord, your lordship will kindly see. No, he has joined, he has accepted this order.
He has accepted.
He has accepted
After
this order.
accepting, he is challenging this order.
And they order,
on
my
the
lord,
ground that he was never terminated at any point of
no,
time.
my lord, the Dulu Devi judgment was only in respect of the person if he has not been terminated. And following the principle of quantum merit that his service was utilized, he was asked to be paid.
And continue.
No, continued, my lord, will kindly find the order.
See, the issue in that case was that that those persons were not terminated.
Were not terminated and therefore
And the order of termination was not served on them.
not served on them.
Correct.
Here, in
Here
fact,
also, as per your instruction, there's no order of termination.
yes, to that, my lord, the Dulu Devi judgment will cover. But my lord, your lordship will find page 50, my lord.
Page,
Page 50, relying on Dulu Devi's judgment, my lord. This, the coordinate bench of this honorable court at para 16 has directed in this repetitions in view of the upper of the order of the apex court in case of so and so in so and so. I find that the petitioner, if they are still in service, are liable to be paid their salaries for the period of work done by them subsequent to July 2007. Accordingly, the respondent shall examine whether the petitioner have worked subsequent to July 2007
in their respective school, and it is found that the petitioners have been working in the schools beyond July 2007. The petitioners should be paid their salary for the period of work done. Now, my lord, to kindly note this line, my lord. It is made clear that until the question of whether the petitioners have been appointed illegally and irregularly is decided by the respondent authorities, the service of the petitioner who are working should not be disturbed. Now, my lord, the reason for why this is, there is a background, my lord, since there was a judgment of this honorable court whereby the teachers whose appointments were found to be illegal and irregular were asked to be placed before the cabinet. And thereafter, my lord, the cabinet has issued an office memorandum, and pursuant to that office memorandum, 2 advertisements were issued where applications were called for examining their case under the screening committee. And
Have you stated that in your affidavit?
somewhat, my lord, but the instruction which was called for by this honorable court, that instruction covers this, my lord.
Your lordship, may I just point out in their affidavit, they have stated it, that they have conducted a screening process and said that I was accommodated as a tutor. Now the question is that when they accommodate me as a tutor on 30/2/2021, prior to that, I was working. Now your lordship will kindly visualize the judgment of Dulu Devi in terms of 2 things. Firstly, they say that they were terminated. Secondly, the court went 1 step ahead and said that if the termination order was not served, they will not be deemed to be terminated. I have projected my case basically on that issue. Yes, they have stated that I was terminated, but when the instructions came, when the court made a specific query, they said that no, there is nothing on record to show that the termination order was served upon me. If that be the case, till today I am not being terminated, your lordship.
Here in that WBC page 39,
Yes, sir.
they also have the in the same footing.
Yes, your lordship. In fact, I was a petitioner in this case, your lordship. I'll just show you. Page 40. Down below, 3819. WBC 3819. Now, next page. Petitioner number 1, Mitharam Datta. So we are on the same footing. So the Dulu Devi's case is I'm squarely covered by Dulu Devi's case.
So in your writ petition,
There is already a directive.
coordinate bench passed this order.
Yes, your lordship.
On the basis of this order, you're getting your salary, correct?
No, your lordship, I was not paid from August 2007.
That's fine.
Yes,
After that, you did not get your salary.
yes.
But then the court permitted them to take whether the appointment of illegal or irregular appointment is decided by the authorities.
Right.
After that, there was some advertisements were made.
And straightway they have appointed me.
You made to it, polling all for this.
This was
person.
prior to this judgment, my lord, this order of 2015. 2012 itself, the process was started.
That's
Initiated.
why.
Yes.
By the time 2015 judgment came,
Yes.
that
That screening process were under
in process.
year one.
So this court did not disturb that process.
That process. Yes.
Have you specified that in your affidavit? That's what I'm saying.
My lord.
Once that is clear, then this court can pass an order.
Yes, because this
Because this judgment
yes.
may have a bearing on the petitioner,
Yes.
but then the facts and
Only in
circumstances
respect
will
of-
start changing
Yes.
from 2017. Because that process which you were trying to verify,
My lord.
whether it is a irregular or
Yes.
illegal
And
appointment.
and based on the recommendation of the screening committee, the cabinet took a decision that the person who has received the salary till 2007, though their appointments were found to be irregular, my lord, those teachers have been accommodated in future by giving a fixed salary, by accommodating them in a supernumerary post. And by accepting this document, my lord, this order itself also put a condition that they will
No, that's why-
relinquish
that's
their
why
past
I'm
services.
asking you.
Yes.
Why don't you bring it by way of an
I-
affidavit?
Your lordship, they have already stated it. They have already stated it, your lordship, in
No,
para
that,
8.
that I've seen, but it is not clearly stated.
Yes.
See, in the paragraph,
Paragraph 8, page 57. And there,
Paragraph
Page 857, here there's.
Paragraph 6.
There is a vague
read with-
statement.
Right, your
There is a
lordship.
vague statement,
Yes.
but it has not been properly
In fact, if your lordship, the by order dated 10/6/2024, this honorable court posed us two questions, madam. Whether the termination order was served upon and whether and how the illegal teacher were accommodated as tutor. These were the two questions.
because that time this fact was not.
That
done
in fact
before.
was not there.
That is why this court is asking you. Because the factual scenario will change after the judgment passed by this court in 2017,
Yes.
when the 15th, when the process was going on, and then the final decision which you took. That's when you bring it up in
Yes.
court.
Your lordship, in
In fact, my
fact,
lord, my lord, if your lordship takes up the instruction, bunch of instructions,
That's I've seen.
there, my lord, we have answered this. How he got accommodated, though he was irregular, my lord.
your lordship, your lordship will kindly record that they have been terming my appointment as irregular. And Dulu Devi came in 2016. So everything they have done is after 2016. And there is this, the principle of law is well settled, your lordship.
Hurt Mr.
Arsina.
Arsina Learned Counsel for the petitioner, Mr. B. Kaushik, Learned Standing Counsel, Elementary
Elementary.
Education Department is permitted 1 week time,
10 days, my lord.
is allowed 2 week time to file an additional affidavit in opposition. So, release the matter on. Yes. 6.
On 22nd,
22nd, there'll be some problem. We'll have it on 27th.
27.
your lordship will keep it as part of your lordship, substantially.
Let the once the affidavit.
7.
None appears for the petition. This is Dr. Ram.
9 and 10.
Well, in this case, they have filed an affidavit and also raised a my lord preliminary objection with regard to the res judicata. According to them, my lord, both these petitions are barred by res judicata or the constructive.
Records are there?
So lordship has also by the earlier order called for my lord, the records of the two cases, 2424 and earlier writ petition 7980 2019.
By which order?
By order dated 15/5
Yes,
2024.
correct.
Records of 7980 and records of 2442 2023. Since they have raised the my lord, question, my lord, so he may proceed the objection what he has, I'll make that. Wait, please. Now, the matter relates to selection of principal of this higher secondary school. Now, initially, the selection was made in favor of the client whom I represent, that is Sojal Kumar Das. Now, some doubt was expressed regarding the B.Ed degree which I had. So that is how, if the lordship would kindly take the affidavit filed by respondent number 6 in WPC 5584 of 23.
Respondent
6.
Yes.
No. Your Lordship should kindly come to page number 129 of that affidavit. Now, this will throw the factual background also. Please come to page 130, my lord. Para 2. Both the petitioner and
You are the respondent number 6? Okay.
both the petitioner, well, in this case, I was the petitioner.
Okay.
The one I am reading.
Presently here you are 6.
Yes.
Okay.
Both the petitioner and respondent number 6 had participated in the selection process for the post of principal of Bamundongra Higher Secondary School in Borpeta district, pursuant to an advertisement dated 35/2019, issued by the then principal of the school. Admittedly, the selection process proceeded under Assam Secondary Education Provincialized Service Rule, as at time the said rules were in force. The procedure for selection to the post of principal is provided under section 13. Section 13(1) inter alia provides that member secretary of the school selection committee shall invite application from the eligible candidates to an advertisement under Rule 13(2), provides that on receipt of application from the eligible candidates, the school selection committee considered on Rule 8(4), after scrutiny of the application shall hold an interview and prepare a panel of names of 3 candidates on the basis of qualities such as leadership skill, administrative ability, integrity, commanding personality, etc. Rule 13(3) provides that the panel of names so prepared by the school selection committee shall be forwarded through the concerned inspector of school to the state selection board constituted under Rule 16 for its approval. Rule 13(4) provides that state selection board, after taking into consideration qualities such as leadership, skill, administrative ability, integrity, commanding personality, shall prepare a select list in order of merit. Rule 13(5) of the select list is prepared by the state selection board, shall be forwarded to the government for its approval, and approved select list would be remain in force for a period of 1 year. As required under the rules, School Selection Committee of Bamundongra Higher Secondary School prepared a panel of list of candidates wherein petitioner was placed at rank number 1, so-and-so, and respondent number 6, Majid Ali, whom my learned friend represent, was at rank number 2. The panel list is prepared by the School Selection Committee was accordingly placed before the State Selection Board as required under Rule 13(3). State Selection Board has provided under rule prepared the select list, which was placed before the government for its approval as required under Rule 13(5). The Additional Secretary to the Government of Assam Education Department in its communication dated 27/7/21 addressed to the Director of Secondary Education of Assam, while giving approval of the government under Rule 13(5), arrived at its conclusion that respondent number 6 may be appointed as a regular principal of Bamundongra Higher Secondary School. By the said communication, it was also provided that petitioner had obtained his B.Ed degree from Borpeta B.Ed College, which is a private college, in the year 1997. And as the college had received NCT recognition only on 14/9/2005, therefore, as per the provisions of NCT Act 1995, the B.Ed degree obtained by the petitioner in year 97 would be an invalid B.Ed degree. The said decision of the government in exercising power under section 13(5) that B.Ed degree of petitioner is invalid is assailed in this petition. R. Majumdar, Learned Counsel for the authorities under secondary education, seeks to justify the aforesaid decision of the government contained in the communication by submitting that under section 14 of the Act, recognition was required to have been obtained within a period of 6 months from the date of the Act coming into force, that is 17/8/95. Mr. S.N. Sharma, Learned Senior Counsel for the respondent number 6, on the other hand, contents the decision of the government while granting approval under 13.5 is a right decision, and respondent number 6, upon being appointed, had in the meantime assumed the charge as the principal. We take note of that in an earlier decision, it had been held in the judgment dated 25/2/21 that if an institute conducted B.Ed course makes an application to NCT for recognition on or before 18/8/97, B.Ed degree obtained through such institute would have to be accepted to be a valid degree. On the contrary, if the application seeking recognition was made at the date subsequent to 18/8/97, B.Ed degree obtained through such institute may not be recognized. It would be construed to be an invalid B.Ed degree. Now, Milord will kindly come to para 11 once. Is very important in this case. Now, no, this very para 11 at page 132. Now, as far as respondent number 6 is concerned, he has no quarrel with the selection made. Selection includes everything. How mark is given, on what basis selection is to be made. So, he supported this selection. Please keep that in mind. I'll come to that little later. So, he cannot be allowed to approbate and reprobate. From his point of view, this selection was good because it selected him and my B.Ed degree was found to be bad. That's the only dispute, nothing else. So, my lord, eventually the order passed is para 15. I'm just putting that to notice, my lord, because it has got relevance in this case. If the order to be, now this is the paragraph, from the para 12, from the aforesaid perspective, when you look into the decision of the government under Rule 13.5, that B.Ed degree of the petitioner is invalid, apparently the aforesaid fact of the matter was not taken into consideration, and neither the materials on record that are available to indicate said aspect was given a consideration by the authorities. From the said point of view, we deem it appropriate to remand the matter back to the approving authority in the government under section 13.5 of the Act to verify from the records as to whether Borpeta BT College has made its application for recognition to NCT prior to 18/8/97 or subsequent to it as provided in the judgment of this court in Pranita Sharma. Now, the only point to be decided qua my client was, if the college from which I got my B.Ed degree, it applied before 18/8/97, then my degree is valid. If it is beyond 18/8/97, my degree, there was no other dispute, my lord. Only thing is, otherwise State Selection Board has given me the first nomination. But it is the secretary who took a view that the institute from which I obtained the B.Ed degree may not be approved, correct? Therefore, in that view of the matter, I had to come before this honorable court in this round of litigation. Para 14. The appropriate authority shall specifically call for the records from the Borpeta BT College as well as from the NCT to arrive at a factual satisfaction as to on which date college made its application for recognition before NCT. Depending upon the materials that may be available, appropriate order may be passed. If the order to be passed by the approving authority in the government is in favor of the petitioner, for the purpose of other consequential action that would be required to be taken, both petitioner and respondent number 6 would be given an opportunity of hearing to put across their respective cases till the approving authority takes its decision, and thereafter the consequential actions are taken. Respondent number 6, principal of Mamundongura Higher Secondary School, shall continue to remain as such. The further continuance would depend on logical outcome of the process as indicated above. The approving authority under Rule 13.5 to take its decision within a period of 3 months from the date of receipt of the certified copy of that. So, my lord, at my instance, the matter was remanded. The fulcrum of the, my lord, remand was that the authority will see whether the application was made before 18/8/97, and if it is, then they will pass an order. Because in that case, my B.Ed degree would be valid. On other count, there was no dispute because they also said the selection is a good.
Let us read that para 11.
Para 11. S.N. Sharma, learned senior counsel for the respondent number 6, on the other hand, contends that decision of the government while granting approval under 13.5 is a right decision, and respondent number 6, upon being appointed, had in the meantime assumed the charge as the principal of the so-and-so school. Now, there are two aspects to it, my lord, in my humble submission. Number one, state selection committee gave me first nomination, second nomination to my learned friend's client. Now, the secretary, because secretary felt that I obtained BEd degree from an institute which is otherwise not competent, therefore he was made the principal. So while he was made the principal, not only the decision of the government that my BEd degree is from an institute which is not recognized, but also his selection is also all right. Otherwise, he has never questioned my selection on any other ground. Only ground was, he never assailed my selection on the ground of any other ground. Only ground was my BEd degree is not good. So from his point of view, other than the BEd aspect, the selection is good for all intent and purpose. Am I clear, Milord?
Then let us put it this way.
Yes.
First, there's the school selection committee.
Yes.
So
Then state level.
State school selection committee recommended your name, number one,
As well as state selection committee.
and the petitioner.
Yes, one me and two to my learned friend's client.
Then the state selection committee also recommended
My case.
your case.
And as one, he two.
But the secretary,
Secretary took the view that the institute from which I obtained BEd degree is not it didn't have the recognition. It's a private college. That's the only point. Am I clear, Milord?
yes.
Yes. Now, so there is a remand. Now, pursuant to this, an order is passed, which your lordships will get at page 118. Page 118. This is 9th of March 23. Read the order of the Honorable Guwahati High Court dated 11/8/21, passed in WPC number 3558 of 2021, and dated so and so, passed in so and so, so and so. Now, my lord, if your lordships, my lord, the reasoning is not written. Anyway, please come to page 119. Sorry, my lord, I'll have your lordship's kind attention to page 118, the second para. Yes. If your lordships will kindly come to page 118, my lord. The second para. Being agreed with that without hearing to the parties and not taking any report from the concerned authority on the authenticity of the document related to his BEd degree, Department of School Education rejected the candidature of the petitioner for the said post on the ground that the petitioner's BEd degree is not a valid as DSC had issued the order to appoint Majid Ali as principal of the aforementioned school. Petitioner filed the instant case. Honorable Guwahati High Court had disposed of the case by the order dated 11/8/21 with a direction that the approving authority in government will verify the records, documents, what was it? I'm sorry, my lord, my copy is slightly ineligible.
Relating to the BEd.
Relating to the BEd degree.
Yes, relating to the BEd degree of the petitioner and conduct a hearing to put their respective cases and will dispose of the matter in compliance of the Honorable Court's order. Hearing was conducted on 20/10/21 at 2 p.m. in the office chamber of the Special Commissioner, Secondary Education Department. Hearing was attended by the petitioner and Majid Ali. In the said hearing, the petitioner had submitted a photocopy of the NCT letter regarding NCT recognition up to the end of academic session of 97-98. Documents were sent to NCT for authentication, while later dated 1/11/21, followed by 3 number of reminders. In the meantime, petitioner filed a contempt petition bearing number so and so, alleging department had not complied with the order dated so and so. NCT has authenticated the document pertaining to the B.Ed degree obtained in Sajal Kumar Das by letter dated so and so. A hearing held on 11/8/23 in compliance of the Honorable High Court's order dated passed in WPC number so and so, filed by Majid Ali. After verification of all related record documents to the B.Ed degree of the petitioner and careful consideration of the above and approval of the competent authority obtained accordingly, it is decided that Sajal Kamal Das may be modified as principal, Bamundongura Higher Secondary School, Borpeta. So, my lord, after a full-scale hearing to both sides, a decision was taken that no, the earlier view which was taken by the secretary is not correct. What is correct is that he has obtained the B.Ed degree from a institute which is not private. In fact, they obtained for renewal and all. Therefore, the degree is all right, and therefore an appointment can be made. In other words, my lord, earlier decision was reversed. Now, hereafter, my lord, on 29/4/23, an order was passed, which your lordships will get at page 120. 120. Next, please. In pursuance of the government approval accorded on recommendation of the State Selection Board, communicated by government letter dated so and so, Borpeta was appointed as regular principal of Bamundongura Higher Secondary School by office order dated so and so. Being aggrieved, first MPNL candidate, namely Sajal Kamal Das, postgraduate teacher of so and so, challenged the selection of Majid Ali before the court hearing bearing number so and so, which was finalized by the Honorable Court by order dated 11/8/21. In compliance of the Honorable Court's order dated so and so, passed in so and so, by order dated passed in contempt petition, which is to the following effect. After careful consideration of the above and approval of the competent authority obtained accordingly, it is decided that Sajal Kamal Das may be notified as the principal Bamundongura Higher Secondary School. In view of the above, the order dated 29/7/21 appointing Majid Ali, postgraduate teacher Asmis of Rihabari Higher Secondary School, Borpeta, as regular principal of Bamundongura is hereby cancelled. In pursuance of order dated 9/3/23 and in compliance of the Honorable Court's order dated so and so and contempt case number so and so, subject to reversion without any notice and without assigning any reason thereof, Sajal Kamal Das, postgraduate teacher of Bamundongura Higher Secondary, Borpeta, is appointed as principal on regular basis and posted at Bamundongura Higher Secondary School in the scale of pay of rupees so and so per month and utterance as admissible as per the rules with effect from the date of his joining. Further, Majid Ali is hereby reverted back to his original post of postgraduate teacher of Rihabari Higher Secondary School, Borpeta, with immediate effect. So, pursuant to order dated 9/3/23, this order was passed. Also, in the meantime, my lord, the contempt proceeding was also there. In the contempt proceeding also, since the government was not complying with the order dated 11/8/21, so a strict view was taken by this Honorable Court. Eventually, they came up with everything and it was found that no, it is our client who deserves to be appointed and accordingly appointed. Now, my lord, my appointment is being challenged. This is where the point of res judicata comes. Now, my lord, will kindly come to judgment dated 19/6/23, passed in 2442 of 23 at page 122. Now, this order is challenged in WPC 2442 of 23. Huh? Huh? Nine, huh? Nine. 10. Now, my lord will kindly come to page number page number 123. It starts, my lord. Now all these things are there. Basically, what was challenge was this order dated 9th of March 23. Please come to 127. Being aggrieved with the order dated 29/4/23, para 6, passed by the in charge director, secondary education, petitioner is before this court on the ground that while Secretary to the Government of Assam Department of Education considered the matter, the judgment was misconstrued and not in conformity with the direction contained in so and so, so and so. Now, kindly see on what premise the writ petition was filed. That this consideration of 9.3, actually 9.3 is the basic consideration, 29.4 is a consequential order. So parent order is Miller 9.3. So their basic case was that while passing this order, certain directions were not complied with. Now, was it not incumbent upon him to also challenge my selection on the XYZ ground? Can you file writ petition on several occasions on several grounds? That's the point. Now your lordship has taken a view. I'm coming to it. I have considered the order dated 9th of March 23. A perusal of the same would indicate that a hearing was conducted by the concerned authority before coming to conclusion with regard to status of B.Ed degree of the present respondent number 6. What was directed by order dated 11/8/21 was that the concerned authority shall call for the records from the Borpeta BT College as well as from NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. The order further directed that it was only when the concerned authority is to issue an order in favor of the petitioner therein, respondent number 6 in the present writ petition, that a hearing would be held with regard to the writ petitioner and present respondent. That was not done. Accordingly, the matter is remanded back to the Secretary of the School Education Department to rehear the petitioner as well as the respondent number 6 on the order that is to be passed by the concerned authority and thereafter pass appropriate order in accordance with law within a period of 2 months from the date of receipt of the copy of this order. Consequently, the order dated 9th of March issued by the Secretary to the Government of Assam is set aside and quashed. While hearing the petitioner, respondent number 6, the rival claim of both parties will be considered. Status quo order passed by this court earlier shall continue. So your lordship interfered with the order dated 9th of March and directed maintenance of status quo. Now, my lord, the articulation which I would like to make is very simple. Now, consequent to that, things have happened. They have passed the order. He has again challenged. There are 2 subsequent writ petitions. Now, the question is, if you are challenging my appointment, is it not incumbent upon you to challenge my selection on whatever ground you may have? You are entitled to 100 grounds, but you must put it in one petition. Now, in this case, you said this consideration was bad, but you never said anything about my selection. On the contrary, in that paragraph 11 of the first judgment, where you supported the selection procedure. Now, can you approve it and reprove it? That is one. And secondly, my lord, can you go on filing petitions like this? Now, following this judgment, he has filed 2 writ petitions, my lord. Then, now, Pursuant to this order dated 18/8/23 order was passed. 18/8/23. Of- Now, my lord will kindly come to WPC 4843. Page 62. Yes. Now kindly note the date 18th of August 23. Now, if your lordship would kindly come to the next page 63. It may to main order. No, then. I'm reading that sub-para, I'm not reading the whole thing. NCT has authenticated the documents pertaining to B.Ed degree obtained in Sajal Kumar Das, while later dated so-and-so. A hearing was held in compliance of the order dated so-and-so. That is, or this order, my lord, which I have read. After verification of all relating record documents to B.Ed degree of the petitioner, and after careful consideration of the above, and approval of the competent authority obtained accordingly, it is decided that Sajal Kamal Das may be modified as principal, Mamundogra Higher Secondary School. So, government reiterates their earlier decision. Now, my submission is, when pursuant to judgment dated 11/8/23, when these orders were passed, first 9/3/23, followed by 24/93, you filed writ petition 2442 of 23, wherein you challenge that the order was not in compliance of the order of your lordships dated 11/8/21. Now, while challenging that, it was incumbent upon you, not only this, the selection is bad on account of XYZ reason. That statement of marks is there, so and so is there. Now, in 4843, there is no stay order. There is no stay order, correct? I'm sorry. Okay. Now, my lord, 4843, he doesn't take all this point. Now, what he does, in 5854, he files another writ petition. Now, he has raised the issue of marks. Please come to 5584. Now, what is challenging? Please come to page 24 of that writ petition. Please come to page 24. A writ in the nature of certiorari, any other appropriate writ order, direction of like nature shall not be issued. Setting aside and quashing the statement of marks errated by the State Selection Board, dated 26/11/20, whereby the respondent had been illegally awarded extra marks and illegally placed in similar marks with the petitioner number so-and-so, 17 marks, and petitioner had been illegally awarded so-and-so. Tomorrow you will, so once your lordship decides this batch of petitions, tomorrow you will come and say, no, he's not an Indian citizen. He could not have got this job. You never know. So is it permissible? In 2442, you should have taken all the points. Now, what does the Supreme Court say on this, my lord? I will rely upon a judgment. My lord, we had made a compilation. Whether, my lord, it is in the record, I remember giving one compilation of the orders. Compilation on behalf of respondent number 6 in WPC 5584. I was suggestion to Koji.
Is it there?
Oh, it is there, Milo.
Just give me the copy.
Citation to my 1989 3 SCC 151. Milord will kindly come to page 21 of that compilation. Please come to para 10. Before we consider the submission made on behalf, the Lordship got it.
Yes.
Before we consider the submissions made on behalf of the tenants, we'd like to point out that some of the tenants who were unsuccessful before this court in Punjab Teen Supply Company case have again filed petition challenging the validity of Section 3 and the impugned notification on additional grounds. In our opinion, the petition by such tenants are not maintainable as the same are barred by the principles of res judicata. Once the petitioner challenged the validity of the impugned notification dated September 24, 74 in earlier proceedings, they ought to have raised all the grounds which could have been raised in impugning the validity of Section 3 of the S3 and the notification. If they fail to raise the ground in an earlier petition, they cannot raise that ground now in the present proceeding. So this is the law. If you, the order to rule to CPC is absolutely clear. If you have got a cause of action, then in that cause, if you assail in pursuance of that cause of action, you must put together all the possible grounds. It's not that today we will file a suit for principal, tomorrow we will file a suit for interest. So basically, my lord, this is based on explanation to Section 11 and order to CPC. So law is very clear. When you file 2422 of 23, while assailing my selection, though it was by way of a remand, you should have also said that this is also bad on account of XYZ reason. Now you have not done so. So these are all based on public policy. Because the litigation must come to an end at some point of time. Public policy demands that litigation between the parties must come to an end at a certain point of time. And these are the, my lord, principles. So therefore, my lord, the question of entertaining the letter to petitions does not arise. So now the issue is very simple, whether my B.Ed degree is valid or not. The examination has to be confined to that. Lordship will do that. But not on the ground that I was given more mark, he was given less mark, is out of question. At least 5584 is out of question. Yes, this 4843 Lordship will examine from the point of view of whether the remand order, pursuant to the remand order, action has been taken or not. But on the ground that I have got less mark, he was given lesser mark, I was given, these issues cannot be gone in. So 5584 is out of question. It is outrightly not maintainable. And 4843, to the extent he questions other aspects, he cannot. Yes, there was a remand order, whether that remand order has been complied with or not, that is an aspect Lordship will go into. In other words, regarding that, whether that B.Ed degree is properly obtained or not, that is an aspect Lordship, not to other aspects. Because in 4483, he, I think perhaps also questions, yes. Yes, to the extent of the B.A. thing, whether this order is in compliance of your Lordship's order or not, that Lordship will examine. Here also he has taken the point of marks that he cannot take. That is my submission of course. To the extent of challenge to 18823 is okay, but other aspects cannot be gone into. At page 23 of Milord 4843, prayer number 1 is okay. I am not questioning that. Of course, on merit there is nothing. 2, a rate in the certiorari appropriate order direction of like nature shall not be issued towards setting aside the impugn statement of marks. This cannot be gone. Similar is the position with respect to all the prayers in 558. So that is my submission, my lord. As far as my BA thing is concerned, there is no iota of doubt now. Everything is clear. Now, if your lordship would kindly come to that compilation, my lord. Yes. If your lordship would kindly come to page 8. List this matter on page 8. List this matter on 12/12/22, enabling ILOM Learning Standing Council NCT to apprise the court as to whether Regional Director, Eastern Regional Committee NCT had replied to the queries made by the state government in secondary education through the letters dated 14/6/22 and 28/9/22, as well as through emails sent to NCT in its mail address. Registry shall reflect the name of ILOM and its standing council NCT under the respondent column in the cause list against this item. Then my lord will kindly come to page number 10. It has been submitted that the state authorities have verified the credentials from NCT about which the NCT has cleared. Accordingly, there should not be any difficulty in issuing the necessary appointment orders. Then my lord will kindly come to order at page 12. Page 12. Mr. U. Sharma, Learned Counsel for the respondent, has produced a copy of the communication dated 9/3/23, by which it is mentioned that NCT has indicated the documents relating to B.Ed degree of the petitioner, and therefore Secretary to the Government of Assam has decided that name of the petitioner be notified as principal of Bamundogra Higher Secondary School. Accordingly, it appears that order of the court is complied with. Hence, this petition stands closed. So, my lord, this is how the court passed an order. After being satisfied, NCT also came forward with their plea. So, there was no doubt regarding the validity of my B.Ed degree. So, that was the only ground on which that initial decision was taken by the secretary, additional secretary, when my learned friend supported this election. Now, all of a sudden, why this election has become bad? That is why it is said, my lord, you cannot approbate and reprobate. When it suits you, everything is good. When it hurts you, everything is bad. So that can't be. Therefore, in this petition, my lord, apart in merit, absolutely there is nothing, my lord, to discuss, as is evident. It is hit by two legal principles. One is principles analogous to res judicata, and other is, my lord, approbation and reprobation. At one point of time, you supported this election, and now you are taking a contrast stand. You cannot. So these are all matters of public policy. Therefore, public policy demands, my lord, that it must come to an end. Otherwise, there will be no end to a litigation. Tomorrow he will come up with another plea once your lordship allows me to join. So that being the position, my lord, these writ petitions, apart from this preliminary objection, my lord, also has no merit. Therefore, this petition should be dismissed. That is my humble submission.
So far as the objection is only confined to the res judicata, not even to the constructive res judicata. So I'll be confining to the res judicata only, my lord. Now, whether, my lord, the issue which have been raised in the present, these two writ petition 4843 and 5584/2023 are res judicata, but by res judicata. So first 4843, my lord, I have challenged both the statement of marks as well as the order dated 18/8/2023. Which according to him, my lord, so far as challenge to the order dated 18/8/2023 is not barred by res judicata. That is a valid that your lordship is entitled to adjudicate. only the second prayer with regard to the statement of marks of the school selection body, that may be res judicata. So half part, he doesn't object to that. And in the next one, 5584/2023, there I am challenging the statement of marks prepared by the State Selection Board. Yes. All along, my lord, I have been submitting with regard to the selection by the school selection committee. The preparation of the marks by the State Selection Board never, my lord, came in picture, my lord. Now, while the writ petition, my lord, the 244843 was pending, sub judice hearing was going on. My lord, on 11/9/2023, by the order of this court, the record was produced. And Lordship may kindly come to my lord, page 54 of WPC 5584. Page 55. The respondents to file their affidavit as may be advised, the records produced be retained. Mr. P.J. Sailor, under senior counsel for the petitioner, may also allow to examine the record if so advised. List on so and so for final consideration is as much as record reveals that both the writ petitioner and the respondents have been awarded 17 marks each. For the first time, this has come from the record, and I was allowed to see. I have gone through the records and I found that the State Selection Board has, over the School Selection Board, they have prepared their own. Earlier, it was School Selection Board gave him 20 marks. I was given 18 marks. Now the State Selection Board has given him 17 marks and I've been given 17 marks. So this statement of statement of marks given by the State Selection Board is under challenge. Now to see whether this res judicata, my lord, this, so far as the state selection marks prepared by the State Selection Board were never under consideration. It was neither known to the petitioner, nor ever communicated to the petitioner, nor any decision was taken on that matter.
But then come to the counter.
Yes. Filed by them, my lord. Yes, yes.
132.
132. S.N. Sharma, learned senior counsel for the respondent number 6, on the other hand, contends the decision of the government while granting approval under section 13(5) is a right decision, and the respondent 6, upon being appointed, had in meantime assumed charge. Yes, madam. Because this writ petition was filed by him and his candidature was altogether rejected. He was ineligible under scrutiny under 13(5), saying that his BA degree being not recognized by the NCT concerned, my lord. So it is invalid. Question of evaluation of marks does not come. And if it is really a fact, which the senior counsel will also admit, if the degree is not recognized, then it cannot be taken into consideration. So I have simply submitted that if it is not recognized, definitely the decision is right. But what is my case? It was never my case that his BA degree is right or his BA degree have the recognition or not. My lord, the writ petition initially, my lord, was filed in 2019 against the school selection, the preparation of the marks by the school selection committee. Against that, I had the complaint. I have submitted with the complaint with the authority. The authority has also, my lord, issued a letter for taking into, my lord, to see that my grievance has been, my lord, taken into consideration, but nothing was done. So therefore, I have approached this court by way of a writ petition number 7980, whose record has been called for. What I am, my lord, praying there, to expedite the process of selection and the objection that I have submitted with regard to the marks discrepancy, that should be taken into consideration. And this court passed an order that yes, you expedite the process and the complaint that has been submitted by him, take into consideration and give an order, my lord. That has, my lord, person to date, what they did not go to the part of the complaint which I had submitted with regard to the complaint. They of their own generated this ground that it is not recognized, etc., etc. On that score alone, he has been, my lord, declared that ineligible. So therefore,
No,
computation-
that is the issue.
yes,
See, when you knew that the state school selection committee
Yes.
has not given you marks
Yes.
appropriate to the particular considerations that are to be made,
Lord,
you made a complaint,
Lord,
correct?
Lord.
And this court, I don't know, I've not seen the record, but then
No,
this court
the-
has sent it back, saying that complete the selection process by taking into consideration
Complaint.
your grievance that you have submitted through your representation.
Lord,
After that, the selection committee, school selection committee forwarded it to the state selection committee. Correct?
but that,
No, that is what happened. According to the records, I
Yes.
mean, I've not checked the original.
state selection board has forwarded it to the government for approval.
No,
And
no, after that, after the school selection committee
Got
made
you.
this recommendation,
Lord,
state selection committee considered that recommendation and it forwarded to the government.
Lord,
Now, till that point of time, you were not aggrieved.
I did not know. That was never communicated.
No, no, you knew it. That's why you came to court prior to that, saying to look into the grievance that
No,
you
no,
have.
this is subsequent. This is subsequent. This is when the writ petition was filed in 2019.
Hmm.
And so far as his order was passed, that is in 29/7/2021. And the writ petition, the first one 7980, that was disposed of on 6/12/2019.
You know what I'm trying to say.
My lord, with the lordship's kind permission, I'm just interjecting. I'm sorry to my mother. My lord, what had happened? When this state selection board gave first nomination to me and second nomination to him, admittedly, my marks were higher from all point of view. Then matter was sent to the government. The additional secretary, what he did, he found something wrong with my BA degree. Therefore, approval was given in favor of my learned friend's client. Then I filed the writ petition. I filed the writ petition. Now, in that writ petition, that para 11 stand is, that's why very significant. Now, he says, in spite of the fact that he was given second nomination, he had no quarrel with anything.
No, that's what I was coming to.
Now the issue is, my lord, when my BA degree was sought to be regarded as constituted as a, illegitimate one, an appointment was sought, he found everything is good. Now, how it has become bad all of a sudden? That is what I wanted to say.
It is not that everything is good. When his selection, the eligibility consideration itself goes. But I being the second, automatically, my lord, there cannot be any comparison with his marks or my marks, my lord. The basic eligibility under 13.5 while scrutinizing by the approval authority found that he is not eligible. The second stage would be, my lord, whether I got higher marks or he got higher marks. That part did not arise. And he challenged that, my lord, that particular, my lord, rejection of his, my lord, candidature as ineligible for being not having a recognized degree. That he had challenged. And I supported to the extent that, yes, if it is not recognized, the decision of the authority is correct.
Okay, let us have a sequence of the writ petitions.
Yes,
that
my lord.
has been filed.
Lordship will come to the, my lord,
The first writ petition.
7980/2019.
You filed it.
Yes, I have filed it.
1 minute. 2000?
7980 of 2019. Lordship. This was, my lord, heard and disposed of on 6/12/2019. The order is available at page 22 of the writ petition in 2442.
Page,
Record also Lordship has called for. This record is perhaps is there, otherwise also in 2424, 2442, I have annexed that copy.
this was the writ petition that you,
I have
the
filed.
first writ petition.
I have filed.
Where you said that there was some discrepancy in the marking,
Lordship.
correct?
2442. Lordship. Discrepancy is there. They are delaying the process. They are not considering my complaint. Though a letter has been issued by the authority to complete the grievance. Lordship will find that order record is there. Otherwise also annexure 2 to the writ petition in WPC number 2442 at page 22. 2442. Since record is 1980 is also there, but it is also 7980. Page 22.
Page?
Page 22 starts 22. Let's may come to page 23. Short order, I'll read it. Heard Mr. So-and-so, also heard so-and-so, Lord Standing Council Education Department appearing for respondent 1. The case of the petitioner is that pursuant to an advertisement dated 30/5/2019 published by the respondent authorities for the post of principal in Bamundogra Higher Secondary School in the district of Borpeta, Assam. The petitioner, being a qualified and eligible candidate for appointment to the post of principal, had applied for the said post, and he also participated in the interview held on 15/6/2019 in this regard. Subsequently, the petitioner came to know that selection committee was contemplating to appoint respondent number 7 to the aforesaid post and had also made a proposal to that effect. Coming to know about such proposal, the petitioner submitted representation to the respondent number 2, that is Director of Secondary Education Assam, requesting for re-examination of the proposal of selection committee, and accordingly respondent number 3, Joint Director of Secondary Education Department, had letter dated 22/8/2019, annexure 3 to the writ petition, requested the respondent number 4, that is Inspector of Schools, Borpeta District Circle, to take necessary step for examining the claim of the petitioner. However, as no steps have been taken by the respondent authorities for re-examination of the proposal of the selection committee to appoint respondent number 7, the petitioner is before this court by filing this writ petition, seeking a direction to the respondent authorities, more particularly to respondent number 6 herein, to re-examine the proposal of the selection committee to appointment of respondent number 7. When the matter is taken up for consideration today, it is submitted at the bar that the writ petition can be disposed of at this stage by directing the respondent authorities to complete the process of selection, which have been initiated by the respondents authorities by publishing the advertisement dated 30/5/2019. In view of the above, the writ petition is disposed of by directing the respondent authorities to do the needful to complete the process of selection for appointment to the post of principal of Bamundongra Higher Secondary School, Borpeta, as per the rules, and also by taking into consideration the aforesaid letter dated 22/8/2019 as expeditiously as possible, preferably within a period of 2 months from the date of receipt of a certified copy of this order. This letter dated 22/8/2019, your lordship will find, my lord, at page 15 of the WPC number 7980. The records perhaps is there. This letter issued by the Joint Director. First page 13 perhaps. Page 13. In enclosing here with a complaint petition received from Muhammad Mazid Ali, subject teacher, Rahabari Higher Secondary School, Borpeta, along with the government letter under reference to examine the allegation in selection process for regular principal in Bamundogra High School, District Borpeta, which is self-explanatory. Hence, you are requested to take necessary step to the concerned school selection committee for examining the same as per the provision of office memo dated so and so, and return the file to this office at an early. So this is specifically based on the complaint submitted by me. Now, what they have done, it was at the director level, my lord. Complaint was filed before the director, the inquiry was to be, was done by the director. Now, at the state of, the approving authority, without taking into consideration of this, my lord, this matter remained there on the ground of that his B.Ed degree is not recognized one, it has been cancelled. So question of comparison of the marks does not arise at all, or the director considering those at that stage does not come. Challenging that, he has filed this WPC 3558 of 2021, which the order he has shown in paragraph 6 that I have submitted. I have just said what I have submitted. Otherwise, I don't have any role. But then, if the degree is not recognized, in that case, the candidature itself goes, so that decision is rightly taken. And this court has passed the order. The full order has not been read out. Your Lordship will see the order, my lord, which he also has submitted and taken, your Lordship, my lord.
No, let us go sequence.
Yes.
After 7980,
That's it. Now the order dated 29/7/2021 came to be passed
the second writ petition was filed by the Yes.
respondent number 6,
that is WBC.
3558 of 2021.
Disposed on.
And this was disposed on uh,
11/8.
11/8/2021. The order is at page 130 of the writ petition 5584.
Yes.
Keeping note of the earlier direction passed by this court, while this court has found that the necessary inquiry for verification of his degree was not done, so therefore it should be done accordingly. Well, in paragraph 13, your Lordship will come, my lord.
Of
Page 133 of the judgment, while disposing of the writ petition number 3558. 130, my lord, of the WPC 5584. Paragraph 12, from the aforesaid perspective, when we look into decision of the government under 13.5 of the rule that the B.Ed degree of the petitioner is invalid, apparently the aforesaid aspect of the matter was not taken into consideration, and neither the materials on record that are available do indicate that the said aspect was given a consideration by the authorities. From the said point of view, we deem it appropriate to remand the matter back to the approving authority in the government under section 13.5 of the Act of 2003 to verify from the record as to whether the Borpeta B.Ed College had made an application for recognition to the NCT prior to 18/8/1997 or subsequent to it, as provided in the judgment of this court in Pratina Sharma Supra. The appropriate authority shall specifically call for the records from the Borpeta College as well as from the NCT to arrive at a factual satisfaction as to which date the college made an application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. Now, very important, my lord. If the order to be passed by the approving authority in government is in favor of the petitioner, for the purpose of other consequential actions that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity of hearing to put across their respective cases till the approving. So this is taking, my lord, keeping note of the earlier order that the order passed earlier, my lord, that they will take into account the complaint that has been filed with regard to the marks. This has been given. Now, by the impugn order, my lord, after this order, my lord, this order itself, my lord, has said that I shall be continued, my lord, till the decision is taken, my lord. Now they have filed a contempt petition for non-compliance of this order, and thereafter an order dated 29/4/2023 has been filed. Which my lordship has seen, my lord. It is purely on the consideration of whether the B.Ed degree is valid or not. So far as my complaint, what was there, what is my claim, what is my claim? I was claiming the marks, scrutiny of marks. That was never, my lord, asked me, my lord. They were directed, if the decision in with regard to the B.Ed degree goes in favor of the petitioner, in that case, both the parties will be given an opportunity to place their respective cases. That opportunity was not given, and the order dated 29/4/2024 was passed. So therefore, I filed the WPC number 2423 of 23. That your lordship will find, my lord, at page 32 of the writ petition.
Same read.
Same writ petition. This has been disposed of on 19/6/2023. Page 33. And paragraph 2 is very important, my lord. Paragraph 2, next page, page 34. Lordship has recited the entire facts. Pursuant to an advertisement dated 35/2019, which was published in Dainik Assam for the post of principal of Bamundogra Higher Secondary School of Borpeta District. The petitioner and the present respondent 6 applied for the said post and also participated in the interview, which was held on 15/6/2019. The school selection committee thereafter prepared a panel list wherein respondent number 6 appeared at serial number 1 with 20 marks and the petitioner appeared at serial number 2 with 18 marks. In the meantime, the petitioner approached this court by WPC number 7980 of 2019, apprehending that the respondent number 6 would be appointed to the post of principal Bamundogra Higher Secondary School of Borpeta District. The said writ petition was disposed of by order dated 16/12/2019, directing the respondent authorities to do the needful to complete the process of selection for appointment to the post of principal of the said school as per rule, and also taking into consideration the letter dated 22/8/2019, which was issued by the Joint Director, Secondary Education Department pursuant to the representation made by the petitioner as expeditiously as possible within a period of 2 months. Thereafter, the petitioner was appointed as the principal of said Bamundogra Higher School of Borpeta District by order dated 29/7/2021, issued by the Director of Secondary Education. Being
See,
agreed.
I'll just interrupt you. After you met your complaint,
Yes.
you came to court saying that they may appoint, that is recorded. Oh. Disposed of, sent down. Then after that, the secretary passed the order appointing you.
Yes.
So he came to court. You didn't have the opportunity to approach this court after the first read. Then after this order was passed, disposed of, filed by the respondent number 6, the secretary reversed his order, appointing the respondent number 6. Then you filed this present this writ petition, 242,
Yes.
challenging that order.
Yes.
At that particular time, you could have taken the other grounds.
Which one, my lord?
You could have taken the other. This when you filed 2442,
Lordship.
2422.
Lordship.
Correct.
Lordship.
When you filed that writ petition 2422, you challenged only the order of 29/4/2023.
Yes. Yes.
When you challenged that order, you could have taken other grounds saying that in that selection, these marks were not given to me. He was given higher marks.
2424.
You had the opportunity to challenge the selection marking in the selection committee given by this in 2442.
Well, this is the only ground I have taken. Only on the basis of marks, not on his appointment as the selection.
No,
as the-
2442. Let
Yes.
us see what is your prayer.
Yes, Lordship, may kindly say again. Yes, that is the only, my lord, the whole ground is that, my lord. Yes, my lord. First pair is, my lord, page 15, my lord, 16, lordship may kindly come, my lord. First pair is setting aside 29/4/2023. Second ground is that to set aside the school selection, the statement of marks decided by the school selection committee. As they are not deciding this school selection committee, for which I have complained of, my lord. So I am directly now, this time I am praying that this school selection committee should be, my lord, should be set aside. And the entire grounds what I have stated in the writ petition with regard to the markings, not on his, my lord, B.Ed degree is valid or not. Since the beginning, my only claim is that his marking is not, my lord, as per the, my lord, notification that has been given. This is the only ground, my lord.
Just
And
can I
lordship-
just come
lordship-
in, my lord, since it is very relevant, I'm sorry. My lord,
I have not
yeah, no,
interpreted.
no, I'm not, I'm
Then-
very sorry, I'm extremely sorry, I'm grateful to my learned friend, my lord. My lord, my lord, I was not aware of this development.
That is.
While, no, no, I'm telling you,
No,
while
that's
going through
what-
the, I'm sorry, I said, I'm sorry. My lord, if you have taken a ground, you have given up that ground, that's all. You have taken a ground, but you have given up that ground, then what is the consequence? Only that much.
Okay. Then in that case, lordship will see what is the order lordship has passed in 2424.
Yes.
Yes. That order, my lord, I was reading, my lord, page councillor,
Yes, page 34.
page 34.
Yes. Yes, given up.
Paragraph 2, my lord, gone, my lord. Being aggrieved, the respondent number 6 filed WPC number 3558 before the court challenging the appointment of the petitioner as principal of the said school by order dated 7/8/2021. After hearing the parties, 3558/21 was disposed of by the order dated 11/8/2021 and the operative portion read as under. Under this 14 and 15 paragraph, which we have already read now, that has been reiterated. Thereafter, the Secretary to the Government of Assam Department of School by order dated 9/3/2023, by which it was held that the respondent number 6 may be notified as principal of Bamundagara High School of Barbeta, as the B.Ed degree of the respondent number was authenticated by the NCT. The operative portion also read as under. Being aggrieved, so and so, lordship has already gone through, my lord. Then, fifth, paragraph 5. Consequently, in charge Director Secondary Education Assam passed the order dated 29/4/23, reverting back the petitioner to its original post of postgraduate teacher, higher secondary school, Barbeta district, and appointing the respondent number 6 as principal of regular basis. Being agreed with the order dated 29/4/2023, passed by the in charge Director Secondary Education Assam, petitioners before this court on the ground that while the Secretary to the Government of Assam Department of Education considered the matter, the judgment was misconstrued and not in conformity with the direction contained in the order dated 11/8/2021 passed in WPC number 3558/2021. What was the direction? Direction was that if the decision on the recognition of the B.Ed degree goes in favor of the writ petitioner, in that case, both the parties will be given an opportunity of hearing to put the rival claims. That was not given. I have considered the order dated 9/3/2023. A perusal of the same would indicate that the hearing was conducted by the concerned authority before coming to a conclusion that with regard to the status of B.Ed degree of the present respondent number 6, what was directed by the order dated 11/8/2021 was that the concerned authority shall call for the records from the Barbeta B.Ed BT College as well as from the NCT to arrive at a factual satisfaction as to on which that the college made its application for recognition before the NCT. The order further directed that it was only when the concerned authority is to issue an order in favor of the petitioner therein, respondent number 6 in the present writ petition, that a hearing would be held with regard to the writ petitioner and present respondent. This has not been done. Categorical finding, they have not gone in appeal. They have also in this writ petition, they have also not taken this ground that marks, challenge of marks is res judicata because I have challenged it earlier case, my lord. In the writ petition 3.5, what he had filed, they have not taken that ground there, my lord. First time, my lord, by this affidavit, they have come with this preliminary objection. Then your lordship will come, my lord. Accordingly, matter is remanded back to the Secretary School Education Department to rehear the petitioner as well as the respondent number 6 on the order that is to be passed by the concerned authority and thereafter pass appropriate order in accordance with law within a period of 2 months from the date of receipt of the copy of the order of this court. Consequently, the order dated 9/3 issued by the Secretary to the Government of Assam Department of Schools set aside clause. While hearing the petitioner and the respondent, the rival claims of the both parties shall be considered. The status quo as on past shall be continued. Now, after this, my lord, they have passed an order on 18/8/2023 at page 49. Page 49. My lord, what they had, my lord, observed in order dated 29/4/2023, same observation confining only to the recognition or derecognition of his degree. So far as the rival claims of the petitioner, that has not been taken into consideration at all. So therefore, I have filed the WPC number 4883 challenging that order dated 18 August 2023. This order and the order dated 29/4/2023, my lord, is just, my lord, replica, my lord. There also my claim was not considered. Here also not the claim was not considered. Now this has been stated, and during the course of the hearing, record was produced as I have already indicated at page 54 of the WPC number 5584 itself. Page 54. First time, my lord, from the record, it reveals the state selection committee has prepared a, my lord, marks. It was never before, all along, my lord, it was, my lord, the school selection committee. So for a state selection board has prepared a list, my lord, that is never, my lord, was, my lord, communicated, or, my lord, was a question, or, my lord, it was revealed anywhere. So therefore, the subsequent writ petition has been filed challenging the state selection board, preparation of the marks state selection board, and which according to me is also not in conformity with the guidelines that ought to have been followed. He has been given marks. So where's the, my lord, question of res judicata comes? My lord, the issue never was before. State selection board, the decision of the state selection board was never before the in any of the proceedings. It was never disclosed by the respondent authority. It was not their claim as well. And section 11 of the CPC clearly says, my lord, the issues which have been adjudicated between the same parties cannot be subsequently reopened. Then what the submission sought to be given is the explanation 4 to the section 11, which is of the constructive res judicata, which ought to have been, could have been raised, or ought to have been raised, has not been raised. Section 11 is with regard to the res judicata, and the explanation 4 is regard to the constructive res judicata. So far as order to rule to does not come, my lord, that is with regard to the claim. If I don't make a prayer. Now here question res judicata is on the issue. First of all, my lord, till filing of the WPC number 4883, I was not aware, or it was never disclosed that the state selection committee has my lord, prepared the my lord, fresh selection marks, my lord, statement of marks. For the first time, I am challenging this. It was never an issue in earlier any of the writ petition. Nor I could have, my lord, hesitated because it was never, my lord, came to surface.
No, 24421 prayer was there, isn't it?
It is for state school selection committee.
That is school selection.
School selection. Till then, it was school selection committee only. They did not say that. There also neither the respondent, private respondent, or the government has said that we have already prepared a, my lord, state selection marks. Nowhere there, my lord. For the first time in this writ petition, I am challenging this 5584 because it has surfaced during the hearing of this earlier writ petition. And so far as the now, yes, he can say, as because the state selection board has prepared over the school selection board. So the second prayer in my earlier writ petition 4883 with regard to the school selection marks statement given by the school selection, it has become infructuous. That at best he can say me. If I'm clear on that, my lord, on the res judicata, I'll just give one judgment, my lord. On that basic principles of res judicata, my lord, what is res judicata and the it's of 2020, my lord. I'll just read one or two, my lord, paragraph. It's a there the facts was such when a decree was put to challenge, some third party has objected to the, my lord, decree before the executing court, claiming that he is entitled to possession. So therefore, he cannot be dispossessed from the suit premises or pursuant to the decree. Though district judge has, my lord, favored him with an order that he is, but then High Court has reversed the order, and he went before the Supreme Court. The Supreme Court has also, my lord, affirmed the order of the High Court. Then he comes, my lord, and file another application in the executing court, claiming that if you don't pay me, you cannot dispossess me. So on that count, my lord, the court has said that it is a res judicata because while you made the claim first time before the executing court that he is entitled to possess, you could have also claimed in the event of his dispossession, he has to be compensated, or the amount has to be on that count. In this case, has said that it is a question of, my lord, res judicata applicable, my lord. Now there, my lord, just below two paragraphs, my lord, paste paragraph 29. AI Online 2019 SC 581. I'll not read the whole, my lord, the first explanation given. The third paragraph under section 11, Lordship has seen third paragraph under paragraph 29, subparagraph
Yes.
third. Under section 11, a matter which has been directly and substantially an issue in a former suit between the same parties or between parties litigating under the same title cannot be raised before a court subsequently where the issue has been heard and finally decided by a competent court. Explanation 4 enacts a deeming fiction. As a result of fiction, a matter which might and ought to have been made a ground of defense or attack in a former suit shall be deemed to have been a matter directly and substantially in issue in such a suit. In other words, explanation 4 is attracted when twin conditions are satisfied. The matter should be a nature which might and ought to have been made a ground of defense or attack in a former suit. Because here he is not claiming, well, the constructive res judicata, he is confining only argument to the res judicata. So, but then this issue was never, my lord, was available for raising it. Then, let's come to paragraph 32. at internal page 12.
Yes.
Seventh line, my lord. Paragraph 32, seventh line. Starts with civil procedure.
Hmm?
Paragraph 32, internal page 12, paragraph 32. I'm reading from seventh line, my lord. The fundamental policy. The fundamental policy of the law is that there must be finality to litigation. Multiplicity of litigation ensures to the benefit, unfortunately, for the decree holder of those who seeks to delay the fruits of a decree reaching those to whom the decree is meant. Well, it is not resisting, my lord, or delaying, my lord. I have been filing one of the author as he also claimed, my lord. Constructive res judicata in the same manner as the principle underlying res judicata is intended to ensure that grounds of attack or defense in litigation must be taken in one of the same proceeding. A party which avoids doing so does it at its own peril. In deciding as to whether a matter might have been urged in the earlier proceeding, the court must ask itself as to whether it could have been urged. In deciding whether the matter ought to have been urged in the earlier proceeding, the court will have due regard to the ambit of the earlier proceeding and the nexus which the matter bears to the nature of the controversy. In holding that a matter ought to have been taken as a ground of attack of defense in the earlier proceeding, the court is indicating that the matter is of such a nature and character and bears such a connection with the controversy in the earlier case that the failure to raise it in the proceeding would debar the party from hesitating in the future. This court will also see whether this state selection board could have been asked earlier. my lord. While we are litigating on my lord, school selection board, the marks prepared by the selection board. My lord, if my lord, this so far as the merit is concerned, he has not contradicted anything.
No, he has not submitted on the merits yet.
My lord,
It's only on the maintainability.
no, he has filed the affidavit.
No.
In the
Today-
affidavit,
Today's argument.
yes, in the lordship. To this argument, he has not replied.
No, it's only on the maintainability.
On the maintainability.
He has not made his argument on mental verification, why making it?
No,
He has
because
also not
my lord,
made
that
any
is the
argument on
principle
that.
of that is the principle, my lord, that whoever claims he is, my lord, to prove his case. Not that I have to, my lord, give the negative my lord, evidence or whatever, my lord, to disprove his claim. my lord.
No, but I mean
Whoever,
is on
whoever
merit
says
has
he
not
is to
made by
submit, therefore I have given the, my lord, my lord, given the senior counsel to, my lord, to submit his point
No,
of argument.
That's why
Lordship, my lord.
from the beginning,
Lordship.
it was on the issue of maintainability,
Maintainability.
of the two writ petitions.
Lordship.
In
On
that
the
case-
merit, on the merit, there is nothing to submit because affidavit has been filed and he has not contradicted anything. And he cannot submit anything beyond the pleadings. That is my submission.
My lord, on reply, I can give a reply on the maintainability because just now my learned friend says he has concluded on his maintainability point. I am entitled to a right of reply. I'll take 5 minutes time. I can give the reply. Yes. Now, my lord, while hearing the matter, I could come to know about this, my lord, WBC 7980 of 19, which was disposed of on 6/12/19. Now, apparently, my lord, in that judgment, sorry, in that writ petition, he had a grievance regarding marking by the school committee. So, my lord, on 6/12/19, this writ petition was disposed of with the direction that this aspect should also be looked into. Now, most importantly, my lord, in the meantime, I filed my writ petition 3558 of 2021, where that order was passed. Now, based on my writ petition, 9/3/23 and 29/4/23 orders were passed when he filed 2442 of 23. So that is where, my lord, my preliminary objection starts. Now, my lord, before I take your lordships to that, please take my affidavit in 5584 of 23. I'll read one paragraph that will suffice everything, my lord. Please come to page 114.
Yes.
That while WPC 4843 of 23 on the same subject matter was pending, the petitioner again instituted the present WPC, challenging inter alia the statement of marks awarded by State Selection Board dated so and so amongst others. Other ground of challenge is that BA degree of the respondent number 6 cannot be taken into account in view of the reasons indicated in the writ petition. Though pursuant to order dated 19/6/23, passed in WPC number 2442 of 23, issue with regard to status of BA degree of respondent stands concluded. Now this is important, that the deponent respectfully states and submits that issue regarding marks awarded to deponent cannot be reopened in view of the judgment and order dated 19/6/23 rendered in WPC number 2442 of 23 as the issue stands concluded. That apart, the plea is barred by constructive res judicata to be raised in a subsequent proceeding following judgment and order dated 19/6. It is a settled principle of law following order to rule to CPC that every petition shall include whole of the claim of the petitioner in respect of the cause of action. Assuming the plea regarding marks awarded in the process of selection was subject matter of challenge in WPC 2442 of 23, but the judgment and order dated 19/6/23 does not refer to the said plea, meaning thereby petitioner gave up the plea. Now at this belated stage, this said plea cannot be raised in the present proceeding. Petitioner having challenged selection and appointment of the deponent, he ought to have raised all conceivable grounds in support of the challenge. Mere assailing of a ground is not enough. It must be pressed into service. The same having not been done, an order dated 19/6/23 rendered in WPC 2442 having attained finality, there is no whisper about the alleged plea of disparity in marks. It is not open for the petitioner to raise the same plea again and again as has been done in WPC so and so and so and so. By the same analogy, the prayer of the petitioner in WPC that deponent obtain BA degree without previous permission as required under the conduct rule also must meet the same fate. Lord, my submission is very simple. Yes, in 2442 you have raised the plea, but you have given up. Now, if he has not given up, you have pressed it, it will appear from the judgment. Now, let us read the judgment. Wherefrom it is there, my lord? My lord, we are all students of law. We'll have to appreciate the legal principles. Please come to my lord, page number 122.
Of the same.
Same, yes, same judgment, my lord.
Also in 32.
Yes. Now, please come to page 127. Now, this order is not challenged by him that my plea regarding disparity in marks was not taken up by your lordships. He has not challenged, either there is a review. This order has attained finality. Kindly come to para 6. Being agreed with the order dated 29/4/23 passed by in charge director, the petitioner is before this court on the ground that while Secretary to the Government of Assam Department of School Education considered the matter, the judgment was misconstrued and not in conformity with the direction contained in order dated 11/8/21. I have considered the order dated 9th of March. A perusal of the same would indicate that a hearing was conducted by concerned authority before coming to the conclusion with regard to the status of BA degree of the present respondent number 6. What was directed by the order dated 11/8/21 was that the concerned authority shall call for the record from the Borpeta B.Ed College as well as from NCT to arrive at the factual satisfaction as to on which date the college made its application for recognition before NCT. The order further directed that it is only when concerned authority is to issue an order in favor of the petitioner therein, respondent number 6 in the present writ petition, that a hearing would be held with regard to the writ petitioner and present writ petition. That was not done. So all that your lordship dealt with was regarding, my lord, the B.Ed degree. Now, my lord, in a writ petition, I can urge several grounds. At the time of hearing, if I only press one particular point, is he not giving up the other points? That is also constructive res judicata. My lord, my learned friend is referring to a judgment on section 11 per se. We also understand what is the purport of section 11. All that we are saying is a concept called constructive res judicata. A point ought to have been urged, not urged. Then what will happen? Whether that point can be urged in a subsequent litigation. A point ought to have been urged, not urged. Now, here in this case, very simple. In 2422, 2442 of 23, you may have taken the ground, but you have never pressed that point. If you do not press the point, what is the position in law? Where is the argument of my learned friend? Where are the materials of my learned friend that he pressed into service the point, and which was, if he was aggrieved by non-pressing, not taking note of the point he pressed, then he should have filed a review petition. He should have filed an appeal against this order. Where is that? My lord, constructive res judicata is not confined to an issue which is substantially an issue in an earlier suit and decided. No, that is the purport of section 11. But by judicial interpretation, my lord, the concept has gone far ahead. Constructive res judicata is a word we don't find in CPC. This is a word we have found because of the judicial interpretation. Now, matter is very simple. In 2442, even if you have taken the point regarding mark, you never pressed into service. At least the order dated 29/4 does not reflect. If you were aggrieved by this, you could have filed a review petition, which you never did. You never filed an appeal against it, that which because his purpose was being served from time to time, because he obtained a stay order. He was continuing without an order. So these are the aspects which are need to be taken into. Now, my lord, if he has taken a point, if he has not pressed the point, he has missed the bus. Therefore, my lord, from whatever angle we look at these matters, the last petition is out of question, my lord. That is, outrightly it needs to be rejected. 4488, yes, that B.Ed aspect I have always said, that to the extent whether 11/8/23 order is good or bad, lordship can examine, but not covering the point of statement of marks. Regarding B.Ed aspect, whether it was properly done. And my lord, my learned friend has said that I have not filed any pleadings on merit. Lord, I think I have made a submission in my affidavit. If your lordship would kindly see, my lord. Para 10 of page 116. Para 10, deponent states and reiterates that plea with regard to validity of selection cannot be entertained in the present proceedings after the judgment dated so and so having attained finality. Even on merit, the plea is without any substance, and in this regard, deponent undertakes to make appropriate legal submission at the time of hearing. At para 10, page 116. So therefore, my humble submission is, my lord, at least on the point of maintainability, the position is very clear. 2442, you may have taken, you have not pressed. Now, what is it? If your lordship want a judgment, I get tomorrow 10:30, I can give a judgment on this point. That if a point is urged and it is not taken to its logical length, then also it will be constituted as constructive res judicata. I can lay a judgment tomorrow at 10:30.
Okay. But Mr. K.N. Chowdhury, senior counsel, assisted by Mr.
S. Hazarika.
S. Hazarika, for the response number 6, as well as Mr. P.J. Saikya, the senior counsel, assisted by Mr.
M. Kolita.
M. Kolita, on the issue of maintainability of the 2 writ petitions. Stop. List for further hearing tomorrow.
But tomorrow I'll place the judgment only.
Okay, okay. Then I said issue of maintainability, no? Hearing concluded, just one reason.
My deep breath.
I'm sorry for troubling your lordship. Item on 1920, your lordship, remember there was a review. But I don't know whether because they are holding the exam, I think day after tomorrow, day after tomorrow. 1920. So when it will be convenient, day after tomorrow, they will hold the exam.
Then we can, tomorrow?
Tomorrow, if I'm not there also, I will do virtual, my lord.
Okay. This item 19 and 20.
20, my lord.
Okay. Item 19 and 20. You just say. How about the other side?
The government.
Go ahead. Mr. Didas, then a senior counsel, assistant.
My
Mr.
planet.
Mr. HK Nath for the as well as K. Gopal and a standing counsel higher education. This matter on 7th.
Tomorrow.
7th.
Yes. I'll do virtual, my lord.
There will be no time left. 13, 14 and 15, could it be on Friday?
On request by senior counsel for the class.
Huh?
9th.
Let it be on Friday, my lord.
Your
I'll
case,
be- Friday, yes.
that review,
7, yes.
Friday.
Because they are going to hold the exam day after tomorrow. Immediately they will not announce.
No, we will not announce.
Oh, that's why let it be on
9th. Okay.
9th.
Make that review one.
9th.
9th.
Because they are going to hold, they are not doing anything after holding also.
Before 15 August, nothing will happen. So after 15 August also, it will take another 1 month. Even we have to take leave from
My lord.
lordship. Even we have to, even
That's right.
before lordship finalizing lordship, we have to take leave from your lordship. Yes, because that's how.
Remember what I told you last
Yeah,
night.
Actually, my learned friend said that they are just directly from the this written test, whatever OMR, they will they will hold the interview. But in fact, we have received a notice now that in pursuance that your lordship has set aside that that notice, recruitment notice, again they have come with we don't mind because that liberty was given. They can come up. There is absolutely no problem. Only what we are worried that we have put on service whether my past service can count it because the view of the court was that as we have given up, we have not given up because there is a treatment that your lordship will look into it on Friday. My learned friend.
We'll
Yes, deeply obliged.
oblige.
If possible, on top of the list on Friday. Okay, it's okay. We'll
what-
mention it.
I'll let it come up.
Let it come up, we'll
Then,
mention it.
You mention it.
Yes, mention. I'm deeply obliged.
Because you wanted the AG to appear.
Yes, yes, he is also. ठीक है, वो mention. Okay, ma'am.
May I please, your lordship? My lord, I beg to mention supplementary order item 29, my lord. Lord, there are some urgency with the matter, my lord, regarding that headmaster selection process, my lord. Lord, may I pray to take up the day after tomorrow, my lord?
But yeah, Buyan, Leonard Council for the applicant. List the matter on.
Day after tomorrow, my lord. 8th of August, my lord.
8 happens.
My lord.
Item number 12, my lord, there's some urgency. I may pray for a fixed date next week on a hearing day, my lord.
Item 12.
12, my lord, withholding my pension after 18 years, my lord.
Okay, on request made by Mr. B. Bharti, Leonard Council for the petition.
But next Tuesday, perhaps, my lord, on 13th.
Okay, 13 hours.
Item number 21, 22.
Yeah.
Any debt benefit expense, urgency statement. 21, 22.
19th?
19.
Huh? List this matter.
May please, lordship, item number 18, lordship, date will be fixed on Monday, lordship.
Why Monday?
Tuesday, then Tuesday. Tuesday.
We'll have it on 14th.
Obliged.
List on-
May I please, your lordship? My lord, item number 16, my lord.
Hmm.
There's a stay vacating IA application. The steps has already been completed and everything has been, pleading has also been completed. My lord, there's an urgency in this matter, my lord. Despite the fact that I have been given the post of principal, because of a court order, I have been not be able to sit in the post. So my lord, may it be fixed on 8th, on Thursday or on 12th?
12th is not a hearing day.
My lord, 13th, my lord.
Okay. Oh, that is item.
16, my lord.
16 and 17.
Yes, my lord, 16, 17.
Just Chowdhury.
Lordship, item 25. So can it be on Lordship Thursday at 2 p.m. if your Lordship directs Lordship?
Item 25.
Yes, Lord. Sorry, 23, Lordship. 23,
Oh, that.
Lordship. That
Okay.
matter, Lordship. If your Lordship directs it to be listed or taken up at 2 p.m. Lordship on Thursday, Lordship.
Her time is Chowdhury and counsel for the petitioner. List the matter again on. You want it on Thursday?
Lordship. Today also, Lordship, my learned friend is not present, Lordship.
Who appears?
JK Goswami. Thursday at 2 p.m. Lordship, he will be informed by.
Then on his request, I'm posting it.
It was while it was part heart Lordship, Mr. JK Goswami was appearing.
On his request.
On we don't have objection.
I don't see his face. That's why I'm.
Yes, yes.
On request made on behalf of Mr. CK's.
JK Goswami.
Was it JK?
JK Goswami,
JK Goswami, learned counsel, learned government advocate.
Lordship.
List on.
Thursday, Lordship, on 8th, Lordship.
Okay.
No, no. No one.
No. Lordship, since the prayer is from petitioner, let the prayer be finished, because then I'll inform the.
Petitioner is not adjourning the matter. And I don't see JK Goswami's face.
Okay. Okay, I shall inform accordingly.
You want it on 8? Okay.
Yes,
on
yes.
8. On 8, what you can do, you can upgrade.
Lordship. Lordship. Obliged.
Item number Lordship 28 Lordship. Pension matter Lordship 2021 matter Lordship. It may be fixed on 20th August Lordship.
Request made by Mr.
BC Dekar.
Mr. Dekal.
On behalf of Mr.
Who?
Or
On
the
behalf
it-
of, on behalf of,
Mr. S. Das Lordship.
on request made on behalf of Mr. Das, counsel for the petitioner.
20 Lordship.
List the matter on 20 August.
20th August.